Good morning, ladies and gentlemen.
Good morning, Your Honor.
Good morning, Judge.
Good morning.
Yeah. Let me know when you're ready. Ms. Bates, what case are you here on?
Morning, Judge. I'm here on Natasha Reeves.
Okay, then let's start with Reed.
Calling case number 240-5500701, the people of the state of Michigan versus Natasha Patrice Reeves. The defendant is being charged with count 1, assault with a dangerous weapon, felonious assault, count 2, weapons, felony firearm, and count 3, domestic violence. That's the probable cause hearing.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drade for the people, P number 60249.
And good morning, Your Honor. Melanie Bates, P76080, appearing on behalf of Natasha Reeves.
Ms. Reeves has logged on, but she hasn't connected her audio or her video yet. Are you waiving her presence?
Yes, Your Honor, I will waive her presence. We have discussed and talked about this case.
All right. Do you have discovery?
I have the paper discovery. I sent over a proposed discovery order for any digital that may exist as well.
And I did send you a link last night.
Oh, okay.
That contains the digital.
All right. What's your pleasure?
Your Honor, we'd like to schedule the preliminary exam.
How is January 17th at 9:45?
Your Honor, I'm going to be in Oakland Circuit that day.
The entire day?
I'll be there. Well, Oakland County is usually the entire day. My case starts at 9:30. There's no telling when I will get out.
Okay, how about January 19th at 9:15?
That'll work, Your Honor.
January 19th at 9:15, final be continued.
Thank you. Have a good day.
Thank you as well. Happy New Year.
Happy New Year to you.
Ms. Reeves, did you get that?
Yes.
January 19th at 9:15. That's in person in 36th District Court, okay?
Okay.
You're all set. Thank you.
Thank you.
Ms. Walrad,
Good morning, Your Honor.
good morning. What can I do for you?
I'm on David Jackson. I don't know if he is in the waiting room.
I don't have a Jackson in my waiting room.
Okay. That appointment came in without any contact information, so if the court wouldn't mind if I wait and see if he does show up, because I need to be able to collect his phone number.
David Jackson, custody. He's in custody.
He was released on tether yesterday, according to the jail's website.
Well, if he's released on a tether, why can't you call the tether folk and get in contact with him?
You know what? That's a good point. I can waive his presence. We can set the case for exam in that case.
All right, let's call Jackson.
Calling case number 230-606-9701, the people of the state of Michigan versus David Lee Jackson. The defendant is being charged with count 1, domestic violence, third offense. The defendant has a third defense notice set to file for cause hearing today.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Veronica Walrad, P85665 on behalf of Mr. David Jackson. We've just discussed off record. I would ask to waive his presence as I'm attempting to find working contact information for him.
Court will waive the defendant's presence. What's your pleasure?
I do have paper discovery from courtesy of Ms. Drain yesterday. I think that digital will probably be arriving shortly and just takes a little while to upload, so I'd ask to set this for a preliminary exam.
Court will continue to plead of not guilty and set this matter for preliminary examination. How is January 17th at 10:45?
That should work, Your Honor.
I thought this was today's. January 17th. We continue. Thank you.
Thank you, Your Honor.
Three.
Good morning, Your Honor. We have a matter that is not before the court technically, Tawanda Williams. She's scheduled for a preliminary exam on the 9th, but the prosecution is asking for an adjournment, and we concur with that. Dominique Grazio, I think, is in the gallery right now. And my client also, Tawanda Williams also.
Judge, I can give you the case number if you need it.
I do. What's the case number?
It's 230-605-9101.
Calling case number 230-605-9101, the people of the state of Michigan versus Wanda Williams. The defendant is being charged with count 1, homicide, murder, second degree, count 2, weapons, felony, firearm, set for hearing today.
Appearances for the record, please.
Dominic DeGrazia, P69815 on behalf of the people.
Good morning, Your Honor. May it please the court, Daniel Reed, P number 30965, on behalf of Williams. We do consent to assume. Ms. Williams, would you state your name for the record, please?
Tawanda Elise Williams.
Thank you.
Okay, so why are we here, folks?
So, Judge, this case was up for a PCC on Tuesday and this Tuesday, the 2nd, and the court set an exam for next Tuesday, the 9th. I was assigned the case after the PCC on Tuesday afternoon. Yesterday, I found out that the officer in charge is out of the country and he doesn't return until the 15th. So that's an issue for me, getting witnesses to the exam and also potentially with testimony for the exam. That's one reason I'm asking for the adjournment. The other reason I'm asking for the adjournment is I talked with Mr. Reed yesterday, He has no discovery. I'm still working on getting all the materials myself. I hope to get him the discovery by Monday, but my concern is that two of the witnesses I would call are children, and I'd really prefer not to bring them to court if Mr. Reed is going to have to ask for an adjournment anyway because he's not prepared for the exam because he just received the discovery so late. So those are basically my two rationales for respectfully asking for an adjournment so that after the 15th of January when the OIC returns.
Okay, so give me a proper as to what your OIC is testifying to.
So I don't know if he's going to be a necessary witness. He is necessary to both get me the discovery that's still outstanding, but also to subpoena the witnesses, get them to court. But this is a case. Well, it may be difficult to get these witnesses here on 2 days with no OIC. They may be here, they may not be. But this is also a self-defense case that he may be a necessary witness. I don't know. I don't know what Mr. Reed wants to argue at the exam. So I would be far more comfortable if he were present for the exam.
Mr. Reed?
Your Honor, we basically don't have any objections to that. We are looking for the pitch talk tape. I don't know if this court requires to issue a special order or have an order signed by this court to receive that. We need that also prior to this.
Okay, so allow me to vent a little bit.
Yes, sir.
It's not at you, Mr. Reed, but for the people. If you guys are going to charge someone with a crime as serious as this, I would expect you guys to have your ducks lined up. And I appreciate, Mr. DeGrazia, that you were just assigned to the case. But I would also think that if you had the gumption to charge somebody with second-degree murder, that you would have at least the minimal amount of information to go forward with the exam that you could give to Mr. Reed.
Judge, unfortunately, the system that my bosses have set up, it's one group of prosecutors reviews the warrants. They look at all the material, but then when it's assigned to the actual prosecutor who's going to try the case, now I have to download all the same material and go through it all over again. It's really a waste of time, but that's the way they want to do things.
Yeah, I wasn't looking for a response from you. Like I said, I was just venting.
Okay.
Thank you, Your Honor.
Because in addition to that, there was another 2 weeks from exam to the probable cause conference when the case was actually set for exam. So that's 3 weeks from the arraignment, and now you're talking about adjourning it even further out. That's inexcusable.
And unfortunately, this matter happened almost 18 months ago, so there has been a long time. We didn't know they were going to charge my.
January 23rd. That date work?
It's good for me, Judge.
We do, in fact, have a trial that's going on that day, Your Honor. We Frank Murphy, Your Honor.
When does that trial start?
On the 23rd.
What kind of trial is it?
Right. It is a a theft crime, Your Honor, that is scheduled for trial.
That is a jury or bench?
Jury trial.
Think you'll be done by the 25th?
Yes, Your Honor, we should.
Mr. DeGracia, 25th at 1:30?
That's fine, Judge. Thank you.
The court's at 1:30?
Yeah.
That's fine.
This matter was originally scheduled for this Tuesday at 10 o'clock, or what time?
11:30, Your Honor.
11:30, okay. Bond, we continue, thank you.
And
Thank you,
Judge,
prosecution. Yes.
Judge, can you just order me to turn over the kids talk video?
Can I do what now?
Can you order me to release the kids talk video to Mr. Reed so that he can review these witness statements?
All right, Mr. DeGracia, you are hereby ordered to turn over kids talk video to Mr. Attorney Daniel Reed.
Thank you, Judge.
No later than Monday.
Thank you very much, Your Honor.
Have a good day, gentlemen.
All right, stay safe, everybody.
You too. Mr. Riggins. Ken Riggins going once. Ken Riggins going twice. Moving on, Ms. James.
Good morning, Your Honor.
Good morning. You all set, Ms. Williams? What can I do for Ms. James?
I have Mr. Garcia.
Good morning, Your Honor. Interpreter is here for Mr. Garcia.
Okay, that's right. You can step in. Mr. Garcia is here, Ms. James.
Yes, I had an interpreter contact him and he indicated it may be better for him to appear in person. He didn't know how to work Zoom.
Okay, that's fine. Ready on Garcia. Okay.
Calling case number 230-606-7501. The people of the state of Michigan versus Osman Obel Garcia. The defendant is being charged with count 1, assault with intent to great bodily harm, less than murder or by strangulation. Count 2, domestic violence, several probable cause hearing today.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Garcia.
Your Honor, Interpreter Evelyn Villarreal, State Certified, number C3822.
Please raise your right hand, Ms. Villarreal. Do you swear or affirm to translate from English to Spanish and Spanish to English to the best of your ability?
Yes, I do, Your Honor.
All right, thank you. And ¿cómo se llama?
Osman Obel Garcia.
Okay.
Osman Obel Garcia.
And what's your pleasure, Ms. James?
¿Y qué quiere hacer usted, señora James?
Judge, we are asking that this be set for preliminary examination.
Su señoría, estamos pidiendo que nos dé la fecha para tener la audiencia preliminar.
Do you have discovery, Ms. James?
¿Ya tiene usted las pruebas recíprocas, señora James?
I believe I saw an evidence.com link this morning. It hasn't downloaded yet, so yes, but I do believe I have it.
Sí, espero que yo las tenga, aunque yo revise esta mañana por el sitio web evidence.com.
All right, the court will continue the plea of not guilty and set this matter for preliminary examination.
Muy bien, así que la corte va a continuar con la declaración de no culpable y vamos a fijar la fecha para tener la audiencia preliminar.
January 17th at 11:15.
El 17 de enero a las 11:15 de la mañana.
Yes, Your Honor.
Sí, su señoría.
All right. We continue. Thank you.
And Judge, if I could just
Answer.
ask Ms. Villarreal to let Mr. Garcia know that I will contact him with the interpreter in the coming days.
Y señor García, su abogada, la señora James, quiere que le deje saber que ella se va a poner en contacto con usted en unos días.
Okay.
Thank you, Your Honor. Have a good one, everyone.
Gracias, su señoría, que todos estén bien. Thank you, Your Honor. Have a good day.
Ms. Segura,
Yes, Your Honor.
what can I do for you?
I have a PCC today for David Daniel.
David Daniel.
Yeah, it was originally scheduled for the 2nd, but it was an old case. There was a child abuse, a prosecutor.
Ready on
So we
that.
said,
Calling case number 12-098-6501, the people of the state of Michigan versus David Raleigh Daniel II. The defendant is being charged with count 1, criminal sexual conduct, 4th degree, force or coercion, HIV and STD testing notice. Count 2, criminal sexual conduct, 4th degree. Set for probable cause hearing today.
Parents, for the record, please.
I'm not sure.
I think Judge APA Carolyn Solari is on this case, and she sent me a text message stating that she's in the waiting room. Okay, there she is. Thank you.
Ms. Solari, your appearance for the record, please.
My apologies, Your Honor. Good morning. Carolyn Solari, P number 86651 for the people.
And good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service on behalf of Mr. Daniel, P86432. And Your Honor, Mr. Daniel is not present today. I unfortunately have not been able to get a new phone number. This case is, I believe, from 2012. So the contact information that we were presented obviously is long. I was given a new investigator, so I'm going to contact her and see if I can get a new number for him and try to locate him. So I would ask, just so we don't set this for a preliminary examination and waste the court's time if I'm unable to do so, I would just ask for an adjourned PCC just to give me some time to locate him, and try to get this case back on track.
How much time are you looking for?
Just a would be fine, Your Honor.
Court will adjourn the probable cause conference to January 12th at 8:30.
Thank you, Your Honor.
I'm sorry, Your Honor. Would you kindly repeat the date?
January 12th at 8:30.
Thank you, Your Honor.
Thank you. Mr. Shulman, good morning.
Good morning, Judge. Sorry about that. I'm here on Dante Hudson. He's in custody. We were going to set it for an exam, but I would like a breakout room with him either before or after. Doesn't really matter.
We'll do after.
Yep, it works.
Ready on Hudson.
Okay, calling case number 240-550-0001. The people of the state of Michigan versus Nathan Jamal Hudson. The defendant is being charged with count 1, home invasion, 1st degree. Count 2, domestic violence, 3rd offense. Set for probable cause hearing today.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Sanford Schulman, P43230, appearing on behalf of Dante Hudson, who is appearing by way of video conference from the Wayne County Jail.
Mr. Hudson, tell me your name for the record.
Dante Jamal Hudson.
What's your pleasure, counsel?
Your Honor, we're asking for an in-person exam and a breakout room to follow after you set a date.
The court will continue to plea of not guilty and set this matter for preliminary examination housed January 17th at 11:30.
Works for me.
All right, January 17th at 11:30, bond will be continued.
And would I be able to have a breakout room, Judge?
Yes, sir.
Mr. Hudson, I'm going to talk to you in a second. Hold on.
Yeah,
Hold on, Mr. Hudson.
I need to talk.
Yep, just relax.
Okay, go ahead and join.
Great, thank you.
Ms. Casco.
Good morning, Your Honor.
Good morning. What can I do for you?
Your Honor, I'm here for a PCC for Kenyatta, and I do see that he's present on Zoom.
Okay. Ready to make here.
Okay. Calling case number 230-606-8901. The people of the state of Michigan versus the defendant, Kenyatta Mayberry. The defendant has been charged with count 1 and 2, assault with a dangerous weapon, felonious assault. Count 3, domestic violence, several probable cause hearings today.
Hearings for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Nancy Castor from Neighborhood Defender Service, appearing on behalf of Mr. Kenyatta Mayberry, P number 80549.
Mr. Mayberry, tell me your name for the record.
Mayberry.
First name, sir, I didn't hear you.
Kenyatta Mayberry.
All right, probably need to clean your lens off a little bit. You look a little smoky. What's your pleasure, counsel?
Your Honor, if we can schedule this for an in-person preliminary examination. I am in receipt of paper discovery. We just received it yesterday. I don't know if there are any discoveries, but if there are, Ms. Drain, would you be kind enough to forward that to me?
Yes, and I don't have it yet. I put in a request with the officer in charge to get that, and I'll send it to you as soon as I can.
How's January 17th at 11:45?
So that's the next time I come.
24, Sharon, it's 24.
Excuse me, Your Honor.
Your Honor, I can do the 17th. What time?
11:45.
Yes, that works for the defense.
All right, you get that, Mr. Mayberry, January 17th at 11:45. That's in person in 36th District Court.
Okay, so I still do come to court on the 15th, correct?
Mr. Mayberry, I'll speak with you in regards to that, but no, you would only be coming on the 17th. And Your Honor, is it okay if I have a quick breakout room with Mr. Mayberry?
Why don't you guys call each other?
Judge, I believe I have I don't have the correct number for Mr. Mayberry, and I just want to make sure that. I'm sorry?
Give them yours.
Sure. Mr. Mayberry, do you have anything to write with?
Give me 1 second, please.
Sure.
Ms. Woodside, good morning.
Good morning, sir. I'm only on your docket to ask you to just get my email for my request.
When did you send it?
2 days ago.
What's your request?
To have a defendant declared indigent.
Did you send over a proposed order?
I did in the email, the motion and the order.
Okay,
I'm at the other job. That's why I didn't have the video on.
Oh, I see that. You look nice in your robe.
Thank you. I'm trying to hide that kind of.
Okay, I'm ready.
I'll resend it, Judge, so it'll be right on top. As soon as I get done this morning, I'll resend it.
Immediately, okay?
Because I sent it to Ms. Arnitha's email, but I realized she was off. So the Madam Clerk I spoke with said to send it directly to your email.
Yeah, Kenneth.King@36districtcourt.org.
Yeah, that's where I sent it, but I'll send it again.
Okay.
Okay, thank you.
Thank you.
I'm ready for the number, Your Honor.
All right, sir. It's 313 418 9144.
So do I call after we get off the Zoom meeting?
Yes, please. Thank you. Thank you, Your Honor.
Thank you. Have a good day.
You too.
trying to leave, right?
I can help you out with that. So we're looking for Mr. Lincoln and someone from NBS or Reyes. And Mr. Cruz. So, is Ms. Brush out there?
Yes, sir.
Take a step in. Good morning, Ms. Brush.
Good morning, Your Honor.
How are you today?
Good, how are you?
Good, good, happy New Year.
You too. Summer? S-O-M-M-E-R-S. Good morning, Your Honor.
Good morning.
Sir.
Are you Ms. Buffington?
Yes, sir.
Good morning, Ms. Buffington. Happy New Year.
Happy New Year to you too.
Ms. Strang,
Yes, Judge.
are you ready on Buffington?
Your Honor, I don't know if anyone has appeared yet. I know that I sent subpoenas for the complainant and
Right.
also the responding officers.
Right here? Yes. Do you have a witness here?
I just checked in on, hallway. The officers aren't here, and I couldn't get in touch with the,
Oh. I'm gonna give them about 10 more minutes. Ms.
Understood, Your
Brush.
Honor. Thank you.
Morning, Aaron. Good morning, how you doing? Wonderful, and you? I'm doing good. It's Friday.
Yes, sir.
Yes.
If you have a charge of an assault and it's dismissed and the jury and concealed weapon, is that dismissed too?
Yes.
So everything's dismissed.
People aren't ready to proceed. Hey, Mr. Lincoln is here. Morning, Mr. Lincoln.
Good morning.
You're here on Strickland?
Yeah, I didn't get to talk to him. Is he in or out? I couldn't tell.
Say he's out? Yes, sir. He's out.
Okay, is he on Zoom?
No.
Well, I haven't had contact. Part of it, they didn't send me. What happened is they usually send you a phone number or some kind of contact, and they didn't. And then I got late last night. They sent me the discovery, and I didn't get a chance to call and see if there's something in the police report with this phone number. Let's see, but I did get discovery. Let's see if there's even a phone. I don't see one. So I would have to maybe send him a letter. I don't know if I could. Maybe I should just set this for exam.
We call the case.
Calling case number 240.
They need to be quiet in your background, Mr. Lincoln.
Yeah, okay. Glenda's talking here. Hold on, I'll put mute on.
Calling case number 240-5500901. The people of the state of Michigan versus the defendant, Darren Dante Strebling. The defendant is being charged with count 1, assault with intent to great bodily harm less than murder or by strangulation. Count 2 and 3, assault with a dangerous weapon, felonious assault. Count 4, domestic violence. The defendant is a habitual offender. 4th offense notice. So probable cause today.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drayden for the people, P number 60249.
And good morning, Your Honor. Steve Mencken, P31562, appearing on behalf of Darren Stribling.
What's your pleasure, Mr.
Your Honor, what I would like to do today is I would like to waive his appearance for today, just set this for an exam.
All right, the court will continue to plea of not guilty and set this matter for preliminary examination. We'll do January 17th at 12 o'clock.
Let me take a look here, just to make sure. Okay, let me just look here for 1 second here. My only, I have to be too far away at 1 o'clock. I got to be in Clinton Township at 1 o'clock. Is there? And I have 2 things in 36. I could do it early that day, maybe. Let me see. See, I already have 2 exams. I have one at 11 and 1:15, and then I have to leave. Is it possible to pick another date?
January 19th at 9:30.
January 19th. Okay.
All right, January 19th at 9:30, bond will be continued.
Thank you, Your Honor. Have a good day.
Thank you as well. Mr. Schuman, you're back.
Yes, Your Honor. Thank you for the breakout room. Wanted to follow up with Mr. Hudson. He's asked me to address bond. Apparently his mother's on hospice and he's got a disabled child, and he is asking the court to consider those for a reduction of bond.
Did he have a bond redetermination here?
Yes, he did. I wasn't present, but I did look that up on the 36th. I saw that.
So what circumstances have changed since then?
Yeah, I don't know again, I wasn't present, but I don't know if that was addressed at the time. His family is texting me just now with some documents that suggest that his mother there is some serious health issues, that she is on hospice, and that he has a disabled son. But again, I would have thought that would have been addressed as well at the hearing on bond yesterday.
It wasn't, Your Honor. I wasn't even able to talk to the attorney that was helping me. They came there then Then when I tried to ask, I'm sorry for butting in, but when I tried to ask the judge, can I say something? He said no. I talked to someone else, my attorney man, and I still haven't heard from him. But this is my first time meeting him, this attorney.
I did receive a verification from the Hospice of Michigan that Veronica Walker is being treated by hospice, and I have an address on Joanne. Again, I'm taking his word for it that he's going to be at that house taking care of her, based on what he said. His bond is, I think, a $5,000, 10%. I'm sorry,
No, it's
50,000.
50,000, 10%.
Yeah, 50,000, 10%. And he says he can't post 5,000. It's a home
Recalling
invasion.
case- Hold on a second. Recalling case 24055000001. People of the state of Michigan versus Dante Jamal Hudson. All right. So, Mr. Shulman, you're back to address bond.
Yes.
Apparently, the defendant has a mother that is in hospice care, and the defendant is asking the court to reduce his $50,000 cash bond.
Yes, that's my understanding. $50,000 cash bond.
No, it's 50,000, 10%.
50,000. Yeah, I'm sorry. He's right. $50,000, 10%. So it'd be $5,000 bond. He's limited means, and he's unable to get a bondsman to facilitate that. And he maintains that his mother, Tamika Stewart, who is currently on hospice through Michigan.
No, it's Veronica Walker. My sister that sent you the stuff is Tamika Stewart.
Yeah, that's right.
Ms. Drain?
I'm sorry, one moment. One moment, Your Honor.
Okay. Are you employed, sir?
I was until I got to see if they're gonna let me get my job back because I've been in here since Christmas. I got locked up on Christmas. I did the 72 hours and mile. They let me out. I went to go back to work, but the detective had called and said I had a warrant for this case. They issued a warrant. I turned myself in. I didn't run. When he called and told me I had a warrant, I came and turned myself into the 10th precinct to get this cleared out because I wanted over because I know I didn't do anything. My truck is the one that had bullet holes in it.
Mr. Hudson, where are you employed?
Okay, you're right. I'm sorry. But yes, sir, I turned myself in.
Where are you employed?
The doctors, I talked to my sisters and them last night. My mother have days to live, sir. Please, I'm begging. Please, can you please let me out to spend time with her before she go? Please. I'm not gonna run. If I was gonna run, I would have ran the first time. I turned myself in. I'm not gonna run.
Where were you working?
Clover's Restaurant on 13 Mile in Little Mac.
Ms. Drain?
Your Honor, I'm not objecting to the request.
We're asking for a $10,000 personal bond.
Court set bond at $10,000 personal. No contact with the complaining witness.
And Mr. Hudson, you got the time, date and time for the exam, January 17th, 2024, right? I think at 10 a.m. Mr. Hudson?
Yes, I got that, and I will be there.
And you have my, and I sent your family my contact information. Okay, Judge, we're all set.
Thank you, Your Honor. Thank you, Your Honor.
All right, sir. Ms. Cross.
Good morning, Judge. I am here on, I'm standing in for Miss Silver. I can stand in for Mr. Cripps.
What are you here for?
I have a case, Jacoby Easley. Miss Silver has a Jasmine Bell.
Oh, okay. So we have Easley and Bell. We're ready on Easley.
Calling case number 230-606-7301. The people of the state of Michigan versus Jacoby Uriel Easley. The defendant is being charged with count 1, assault with intention to create bodily harm, less than murder or by strangulation. Count 2, domestic violence. That's a probable cause today.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Sarah Kraus, P81830, appearing on behalf of Jacoby Easley. Judge, I have reached out to Mr. Easley by phone and by letter. I have not been able to contact him. I'm asking that his presence be waived and an examination be set.
So why would I do that? You can't contact.
Judge, it's up to the court, but I have not had any contact with him.
By phone or letter. Court's going to issue a capious revoked bond and set a new bond of $25,000 cash here.
Thank you, Judge.
Okay, we're ready on bail.
Calling case number 23059-03101. The people of the state of Michigan versus Jasmine Lashea Jacquel Bell. The defendant is being charged with count 1, criminal sexual conduct, 4th degree, force or corrosion, sword notice, HIV and STD testing notice. Count 2, criminal sexual conduct, 4th degree. Several probable cause hearing today.
Appearances for the record, please.
Good morning, Your Honor. Kristen Cartwright on behalf of the people, P82411.
And good morning, Your Honor. Sarah Kraus, P81830. I'm standing in for the attorney of record, Gabi Silver, for Jasmine Bell. Miss Bell is in the Wayne County Jail, Judge. She was on screen before Judge Patricia Jefferson this morning for a competency hearing as well. I'm asking that her presence be waived.
The court waived the defendant's presence. Do you have a report back?
Judge, we are in receipt of a report regarding Miss Bell's competency. The report did find her competent. We are requesting an independent examination at this time.
You have a doctor in mind?
Yes, Dr. Atara Abramsky.
Can you spell that for the court reporter?
First name is Atara. Last name is Abramsky, Abramsky.
All right. And how long is Dr. Abramsky requesting?
Judge Jefferson actually set 30 days to have the report done, so we're going to have it done within 30 days.
Okay. All right, I will adjourn the competency hearing to February 5th at 8:30.
Thank you, Judge.
Thank you.
Thank you. Mama, we continue.
Thank you.
February 8:30. Mr. Reyes, we're just waiting on your attorney, sir. let's have, the vote on Buffington, step back in. Okay. Recalling 2360356, people of the state of Michigan versus Nicole. Defendant is charged with count 1, assault with a dangerous weapon, count 2, weapons, felony firearms, count 3, carrying a concealed weapon, count 4, firearms, careless discharge, property damage over $50, count 5, domestic violence. Here's the record, please.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
Good morning, Your Honor. Name Print Defender Service by Summers Rush, number 85828, appearing on behalf of the Buffington, who's present today. Ms. Buffington, please state your name for the record. Nicole Ashley Buffington.
There's a date time set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
How many witnesses will it be?
1, Your Honor.
Okay. Call your witness.
Yes.
Here. What's the name?
I'm sorry, Your Honor. Let me just make sure which one's here. I apologize.
Okay.
All right. Thanks. Your Honor, the people call Officer Grow. G-R-O.
Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? Please give your name and spelling to the court report. You may begin when you're ready.
Thank you, Your Honor. Slow internet. Good morning. Please restate your name for the record.
Officer Brandon Burke.
Okay, and are you currently employed?
Yes.
Where are
Please
you
speak into
currently?
that microphone.
Detroit Police Department.
Where are you currently employed?
Detroit Police Department, 6th Precinct.
Okay. And how long have you been employed?
6.5 years.
Have you? Were you employed on the day of October 21st of 2023?
Yes.
So that would be last year?
Yes.
Okay, did you work on that day?
Yes.
And did your work as a police officer take you to the location of 7747 Penrod Street, Detroit, Michigan, in the city of Detroit County of Wayne?
Yes.
Okay. Now, why were you there?
I believe I got a police run right on domestic violence situation.
Okay. Now, is there any, when you arrived at that location, is there anybody in this courtroom today that you recognize?
Yes.
Okay, could you maybe point them out and tell me something they're wearing?
Yes, Miss Buffington.
Okay. All right, so what happened when you met?
The record should reflect the witnesses identified. Ms. Buffington.
I apologize.
Nicole Buffington.
Okay, now when you arrived at the scene and you met Nicole Buffington, who you just identified in court, what happened?
I believe she had her hands up in there.
Okay, so then based on that, what did you do?
She stated she had a gun. So me and my partner approached her, and at the time, the partner grabbed the gun off of her.
Okay, so then based on that, what did you see?
As in terms to what?
But when you saw him do that, what did you do?
Saw who didn't?
You just said you saw your partner grab a gun?
Yeah.
Okay, then what happened?
We had a brief conversation with Ms. Buffington.
Okay. Okay, then after, based on that, then what did you do?
We ended up doing a report for Ms. Buffington.
Okay.
We secured her firearm for safekeeping. We put it at the 6th precinct.
Okay, do you remember the firearm?
Yes.
Okay, what was it?
It was a tan CZ.
Okay. Now, when you say it was seized off of her, where was that?
It was in her purse.
It was in her purse. Okay, so you did, so you saw, so it was your partner that took it out of the purse?
Correct.
Okay. So then what happened to it afterwards?
We put it in safekeeping at the 6th precinct.
Okay. Do you remember the evidence tag that you used?
I don't recall the number on
Okay, if I was to show you a screen with the number on it, would that refresh your recollection?
If I had a chance to look at my report, it would probably be in my report.
Okay. May I just want to put this. This is please. Okay, Your Honor, may I approach? May. Has your recollection been refreshed?
Yes.
Okay, so do you remember what the evidence tag was?
I don't remember the number, but
okay,
it's in my report.
Okay, thank you. All right, nothing further. Cross-examine.
Good morning, Officer Grow. So, you were called to the address of 7747 Penrod Street, correct?
Correct.
And so you arrived there with your partner, and you get out of the car, and it's dark out, right?
Correct.
It's late at night.
Correct.
And you see Miss Buffington with her hands up approach you.
Yes.
Slowly, right? And she's letting you know that she has a gun.
Yes.
For yours, I mean, presumably for your safety and for her, right?
Yes.
And that was, in your professional opinion, was that was a smart thing to do, right?
Yes.
Okay. And now this address, that is Miss Buffington's listed address, isn't it?
I'm not 100% sure.
So you prepared a report in this case. Presumably, you looked up her address, right? And you would write it down.
My partner with the young person.
And that would be in the report, right?
Correct.
And so it's in the report, is it not, that Miss Buffington's address is 7747 Penrod Street?
If it's in the report, I think it'd be in the report.
We're reviewing the report, refresh your recollection on that matter? Yeah.
Yep, state their home address, 7747.
So this address, 7747 Penrod Street, that is Ms. Buffington's listed address, that was the address that you came to. And that was the address that Ms. Buffington walked from.
I don't know if she walked from there, but.
Okay. And she wasn't arrested right away, was she?
No, she wasn't.
You ended up taking her in the police vehicle unhandcuffed, right?
A different scout took her.
A different scout. So it wasn't, so you recovered the weapon for safekeeping, but at that point she was not arrested for carrying a concealed weapon.
No.
I can have one moment. No further questions.
You redirect?
No, Your Honor.
Sir, when you encountered Ms. Buffington, where was she exactly?
She was standing in the middle of the street.
She was in the middle of the street. She wasn't in the curtilage of her home.
No.
And did you see the gun before it was recovered from her?
I didn't see it. It was in a bag, but I saw it.
It's in a bag where?
I think the first. And it was in the bag.
All right. She told you that she had a gun.
Yes.
And were you able to receive a CPL from that?
No.
Any questions based on my questions?
No, Your Honor.
No, Your Honor.
Thank you, sir. You may start. Any other witnesses?
No, Your Honor, and I just would like to make a record that that Brandon Walker is the complaining witness that was for the felonious assault charge, and we have not been able to make contact with that person at those two incidents.
Okay. So I take it you will not be moving to bind over on count 1 or count 2 or count 4, count 5.
That's correct, Your Honor.
Moving to add a count 6 carrying concealed weapon.
I believe that was part of the chart. That was the warrant I'm looking at does say very concealed.
Where is that? I don't see that information.
Could be wrong.
It's count 3.
Count 3.
Oh, it is count 3. I'm sorry, I missed count 3. Okay, so you're just moving to bind over single count 3.
That's correct.
All right. Ms. Brush.
Your Honor, I'd asked to dismiss count 3. I don't think people have met the standard of probable cause here that Ms. Buffington did not have that weapon in her weapon. The officer's testimony made it very clear that.
Didn't you just testify that she was in the middle of the street?
Yes, but Your Honor, if I can, we have a police car pulling up. Ms. Buffington makes it clear right away to police officers. She's the one, they had been called to her address. She wanted to make it very clear to them right away that she had a weapon on her. And right before then, presumably, based on the officer's testimony, she was at her own address. She was at her own listed address. The officer testified to. That's the address that they were called to.
They're counting her in the middle of the street.
In an abundance of safety.
Let me see if I can explain it to you differently. How would this be any different than the person who claims that they are open carrying on the street and then they get in the car? Now they're no longer open carrying because the pure dimensions of the vehicle make it concealed. How is that any different that if she's lawfully carrying a weapon in the house and then she goes outside of the house to the street? Isn't she now carrying a concealed weapon?
Your Honor, what I am saying here is that when we have situations with police officers where people are put at risk just by the very nature that they have a gun, she was doing her part in making sure the weapon was
I'm
known.
looking purely at the charge and the elements of the charge. The weapon was concealed in a bag, according to the officer. She was in the middle of the street.
And based on the officer's testimony, they pulled up to the place. She was right outside of that. Even if technically she had left the curtilage of the home, she had already observed them. She had seen the police officers right there. And she knew that she needed to tell them that she had a weapon. Right before they had arrived.
Because that's not anything I heard at the
Well,
exam.
Your Honor, I rest my argument on that, but when we think about why we have a carrying concealed weapon charge, this is not a proper reason for someone who may call the police to then be charged with a crime when she did everything in her power to ensure the safety of the police officers and herself.
Any response?
Your Honor, the people have presented what would be enough to bind over for count 3. It seems to me like that's a fact-based question that she's asking. It seems to me as though it's a good idea. It seems to me like that this is something that's prepared for the trier of fact.
All right, although I appreciate Ms. Buffington alerting the officers that she had a gun on her person, the fact of the matter is that she was not within the curtilage of her home, that she done so while on the porch of her home or inside of her home or something like that, we would have a different scenario. But according to the officer's testimony, she was in the middle of the street and the gun was on her person and it was concealed. That's all the people have to show for the purposes of this hearing, is that she was in possession of a firearm and that firearm was concealed. That being the case, the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint. I know it doesn't really sound fair or sound right. I've had cases where I think the most troubling case I've ever had was a guy who actually called the police because someone had broken his house. He chased the guy down the street trying to get the identity of the person. He had the gun in his waistband. As the officers pulled up, they saw the gun in his waistband covered by a jacket. And they arrested him for carrying a concealed weapon. And he's the one who called the police because someone had broken into his house. And he was charged with carrying a concealed weapon because that weapon was concealed in his person and he was not within the curtilage of his own home. So similar circumstance here, unfortunate, but the people have met their burden. The defendant will be bound over to Wayne County 3rd Circuit Court Criminal Division for the proceedings. Her arraignment on information date and time will be January 19, 2024 at 9:00 a.m. Bond will be continued.
Thank you, Your Honor.
Thank you. Oh, and I'm sorry, counts 1, 2, 4, and 5 will be dismissed for insufficient evidence.
Judge,
Yes,
with my raise,
you haven't seen an attorney yet for raise. Mr. Max.
Morning, Judge. How are you?
Good. How are you? What can I do for you? Happy New Year, by the way.
Happy New Year to you. I'm here on the Dixon matter. Except for 9:30.
Except for what?
9:30.
Okay.
Prisoners haven't come to the county yet.
Oh, wow, really? It's no problem.
Yeah, dismissal goes up. Make a motion.
Oh, yeah.
3. Separate.
They can, dismissals can all go on the same. Ms. Brush, can I get dismissals for those other counts?
Let me get that.
Okay. You're here on Willoughby as well?
Willoughby, yes,
and Williams,
and Williams and Long.
Oh, it's my Miss Brush Day.
Yes.
All right. Where is Mr. Wood? Oh,
He's in custody.
And you haven't brought him with you.
Oh,
Who are the others here on?
I'm here on, Stephen Williams, who is here. And Nancy Long, who's also here.
Mr. Magus, your client is in custody as well?
She is here.
Okay, we're still waiting on the prisoner. You say Williams is here, Ms.
Yes.
Burns? Okay, let's do Williams.
County's here, not in process.
Huh?
County's here now.
Are they here now? Where's my prosecutor? Yeah, we're ready on Stephen Williams.
Your Honor, I've been told that no one for us, for the prosecution has checked into the courthouse yet.
Okay. Calling case 2360559, people of the state of Michigan versus Stephen Edward Williams. Defendant is charged with count 1 assault with a dangerous weapon, count 2 domestic violence. Appearances for the.
Good morning, Your Honor, Eric Decker, PA 5931 with the people.
Good morning, Your Honor. Neighbors Defender Service by Summers Brush, number 85828, appearing on behalf of Steph Williams, who's present in the courtroom. Mr. Williams, please state your name.
Today's the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, no, the people's witnesses have failed to check into the courthouse.
Your Honor, we would.
So ordered, the court will dismiss this matter without prejudice. Any dismissal order?
So Williams,
Yes.
yes. Break off a second. No, I'll break off a second.
Okay. We have witnesses for Willoughby.
We do, let me just, yes, let me just check it.
And I need to speak to him.
Okay, while we're doing that, how about for Dixon?
I understand, no, not on Dixon, just no IC. Okay. No on Dixon.
Okay, so let's do Dixon.
Okay, great, thank you.
We don't have Dixon up yet.
Few minutes.
Want to waive his presence, purposes of the dismissal?
I can waive her presence.
Her presence, I'm sorry. LaPortia Dixon. Calling case 2360496 for state of Michigan versus LaPortia Marie Dixon. Defendant is charged in count 1 and 2 assault with intent to murder. Count 3 and 4 assault with intent to do great bodily harm, to murder or by strangulation. Count 5 failure to stop the scene of accident resulting in serious impairment or death. Count 6 reckless driving causing serious impairment of the body function. Count 7 and 8 assault with a dangerous weapon. Count 9 domestic violence.
Your Honor, I just got a text from the prosecutor that was gonna do this, and could we just wait for a few minutes, please? Sure, thank you. I apologize, I really do. Okay.
Get another copy.
Yes.
Yeah, almost. Hey, you all right?
Yeah, how are you?
Good morning. Happy New Year.
So you've been on for a while.
Oh, Happy New Year to you too. Yeah.
You better know all that. Just they'll wait. So sure. Dixon's up.
What's going on with Dixon?
Okay, I'm ready to go on the record for it. It's, yeah, we don't, all I have is an OIC. Apparently they want to do a witness detainer on Dad because they're trying to serve him, but apparently they've failed to actually serve the subpoena. I'm supposed to ask for a second chance and up to you.
All right. This is how this needs to come up.
Your Honor, let me grab the OIC, make sure he's in here for this.
Okay. Can you get NBS to call and see who's supposed to be on the rails? You know, rails.
Still makes your turn.
recalling 2360496 for the state of Michigan versus LaPortia Marie Dixon. Defendants charged in count 1 and 2 assault with intent to murder, counts 3 and 4 assault with intent to great bodily harm, less to murder or by strangulation. Count 5 failure to stop the scene of accident resulting in serious impairment or death. Count 6 reckless driving causing serious impairment of the body function. Count 7 and 8 assault with dangerous weapons. Count 9 domestic violence. Appearances for the record.
Morning, Your Honor, Eric Decker, PA 5931 for the people.
Morning, Your Honor, Mark Magidson, number 25581, and Ms. Dixon. Ms. Dixon, could you identify yourself?
Question, Dixon?
There's the date and time set for preliminary examination. Are you ready to proceed?
Your Honor, first of all, I'd also like to say I'm standing in for an attorney of record, Brent Bailey. Well, from what I understand, that we have, the complaining witnesses have not been able to check into the courthouse. I do have the officer in charge right behind me. If you would like to, please state your name for the record.
Investigator Michael Jameson.
Michael
Jameson.
Jameson.
Investigator Jameson has informed Brent Bailey that he has attempted to subpoena the complaining witnesses, and we are considering a witness detainer in this case. We'd ask the court for another opportunity of preliminary exam so that we can get those. So if the coercion is necessary to get those particular witnesses, then we can do so.
Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. What efforts did you make to serve who?
I have talked to the 10-year-old's mom. He just got out of the hospital. The dad had not been able to speak to him. I left a message for him. But when I spoke to her, she said they were coming together.
Okay, so the complaining witness in this matter is a child?
One of them is a child and one is an adult.
One is the child, one is the adult. Okay. And what's the adult's name?
Gregory Person.
Gregory Person. And the child is at Raynell Person?
Yes, sir.
And you've been unable to serve Gregory Person?
Yes, sir.
But you have talked to him?
I did not speak to him. I spoke to the boy's mother, and she said that they would be here today. I mean, Gregory.
When did you last speak to him?
Last night.
Have you made any efforts to contact him today?
I just called her phone number before I came in. I didn't get an answer, but I hung up before it rang.
When did you try to serve him?
Last night.
What happened when you tried to serve him?
I couldn't get Mr. Kurtz on the phone, but I got with Raynell's, the young man's mother, and she told me that him and Mr. Kurtz, they were coming together. That was their plan.
So you didn't try to personally serve him?
No, sir.
Why not?
Actually, I'm on vacation, sir. I didn't have a chance to, sir. I'm sorry.
Mr. Mayor?
Judge, I respect the fact that the officer in charge is on vacation. My client's in jail, and they've had weeks to prepare to serve these complaining witnesses, and there's other officers on the Detroit Police Department who could actually take the place of Officer Jameson. I think there's an obligation of due diligence that has not been met here. And I think that balancing the interests of justice, I understand this charges are serious, but my client's right to due process, my client's right to be free from incarceration is at jeopardy here. I would ask that the case be dismissed. Of course, if the charges are serious, they can always be charged. That's an option. It's not going forever. So I think at this point, I believe that people have failed to show any due diligence in trying to serve the individuals here, and that the case be dismissed without prejudice.
Did you say the child was hospitalized at some point?
Yes, sir. He just got out of hospital 2 days ago.
I've had information, Judge, that the child was out of the hospital 2 days after Christmas. And we recognize he was in the hospital, but he's been out for well over 10 days.
How old is the child?
10. And the child has joint custody between Mr. Curse and the child's mother. So there's the child's parents. And so there's been availability. Both Mr. Curse has been around, the child's been around, so forth. And I don't believe that there's been any effort to secure those witnesses here.
All right. Issue is, however, that people were led to believe that the witness was going to show up. I acknowledge that one of these witnesses is a minor. It has to pretty much rely on the other witness to get him here. Given the seriousness of these charges, the court is inclined to grant a very brief adjournment and sign a witness retainer. That brief adjournment will be, if I have anything available. Oh, I got an opening on Tuesday now, because that homicide adjournment that was scheduled for 11:30. Rosie. Mr. Reed, was it? It's 17130, Mr. Williams. It wasn't. It was 11:30. It's scheduled at 11:30. It's Wanda. Who? Wanda Williams. Yeah, Wanda Williams. That was scheduled. That got adjourned. Williams got adjourned, wasn't it? Yes. Okay. I can do Tuesday. That was at 11:30. Right. I can do Tuesday at 11:30.
Okay, I do tentatively scheduled for something at 9 a.m. 50th District Court. So that should.
Okay. All right. So I will adjourn this matter to Tuesday at 11:30 a.m.
Was there
the GSU report? Yes. I recommend no action.
That's it. Well, I take the courts.
Okay. All right. Final be continued. For final, let's pause for the adjournment.
Okay, thank you. Come on.
Okay.
All right.
That's okay.
Oh. Okay, Ms. Brush, we're ready to move now.
Wait, so wait. Willoughby.
Let's have Simi Willoughby.
Yeah. Let me just make sure that.
I was told you to wait.
Oh, it's wait. Oh.
Willoughby.
I want to see if I need a third. Okay. I guess I don't. Thanks. Oh, yeah. 2 minutes. Yes.
Calling case 2360533, people of the state of Michigan versus Simmons Lloyd Willoughby. Defendant is charged in count 1, weapons, firearms, discharge, enter the building. Count 2, weapons, firearms, possession by felon. Count 3, assault with a dangerous weapon. Count 4, assault with a dangerous weapon. Count 5, 6, 7, 8, felony firearm. Count 9, domestic violence. Defendant has a condition for the fourth offense.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
Good morning, Your Honor. Neighborhood Defender Service by Summons Fresh, number 85828. Appearing on behalf of Cindy Willoughby, who is present in the courtroom today. Mr. Willoughby, please state your name for the record.
Today is the date and time set for preliminary examination, counsel.
Your Honor, this time I have advised my client of his rights and he wishes to waive his preliminary examination.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, you put your hand down. By waiving the same, that means you won't have one. You'll be bound over to Wayne County Third Circuit Court as you stay in charge. You understand that, sir?
Yes, sir.
You understand the nature and the purpose of the preliminary examination?
Yes, sir.
You understand if you were to have one, the prosecution would have to establish that the crime you're charged with is committed in the city of New Jersey that is probably cause to believe you committed it.
Yes, sir.
Is anyone forcing you to waive your right?
Yes, sir.
Has anyone promised you anything?
No, sir.
Are you waiving your right freely and voluntarily?
Yes, sir.
Any objection from the people?
No, Your Honor.
Court finds the defendant's waiver is made knowingly and voluntarily freely given. The court will therefore bind the defendant over to Wayne County Third Circuit Court, Criminal Division for the proceedings. His arraignment on the information date and time of January 12, 2024 at 9:00 a.m. Let me get you guys to sign this waiver.
Your Honor, if I may have a quick second with the counsel. Okay. Your Honor, we have one more matter on this. In my discussions with the complaining witnesses this morning, they say that there has been an attempted third-party contact by the defendant, sending people that are related to him to talk to the witnesses, and we wanted to bring that to the court's attention.
Your Honor, I have no information about this at this time. I was just informed by the prosecutor who just heard from the witnesses as well. You know, I don't any reason to believe that that has happened. I know that there was a past relationship with one of the main witnesses and their lives were entangled, but it seems like based on what Mr. Deckridge just said, there hasn't been direct contact with anyone. It could just be things going through the grapevine. Based on this third party contact. Without any more information, I'd ask
you guys to sign the waiver. I didn't mean to interrupt. One, two.
Your Honor, the complaining witnesses are here if you would like to speak to those matters.
Your Honor, I have no other representations to make. I was going to address Mr. Willoughby's bond for you. I don't know if we should do that right now or if you want further information. So right now, Mr. Willoughby has a $50,000 cash bond. I'd ask that be reduced to a personal bond with Heather, GPS Heather on house arrest. Before this, Mr. Willoughby was working, before he was arrested, he was working at Save. His wages are simply not enough for him to post this sort of bond. Based on his income level, this is an excessively high bond here. I can understand why the court might have some concerns about a personal bond due to the nature of the charges. However, Mr. Willoughby's ties to his family are an important factor that I think the court should consider and show that a personal bond with Tether on house arrest would be sufficient for supervision. I have been in contact with his sister, Gloria. Mr. Willoughby has 2 adult children he's very close with. He's close with his oldest brother, James, and his boss at the compensated, is willing to be an advocate for him. And I talk about these people not only to demonstrate these ties to the community, but also I think that should quell the court's concerns, if there are any, about Mr. Willoughby's ability to adhere to the conditions of a bond. Because in my experience, having a support system makes it much more likely that someone is able to stick to the conditions, to stay at home, to do what they need to do to abide by the court's orders. And so for that reason, I would ask that this be reduced here. I don't have any more information about what any contact with these witnesses. However, once again, it does seem like that it's all indirect. We might be talking to some people who then talk to other people, not on his orders.
That's
but
all
just
he
because
can
they're
do
in
if
a
he's in jail, right? You can't have any direct contact.
Well, but presumably, if he wanted to, he could make phone calls, and it's clear that he hasn't done that to the witnesses directly themselves. And there's been no testimony or no evidence offered here that anyone was speaking to the witnesses on his orders, on anything that he
So those
told them.
witnesses are in the hallway. You want to hear from?
We could absolutely do that. It seems to be as though, it sounds as though the friends and family and support structure are specifically who has been going to the witnesses and asking them not to be able to. So it seems as though those specific people that are cited by defense are exactly the people that are involved in the bringing the third party contact.
So before me, I have a defendant that is charged with 9 different counts. And he also has a habitual offender 4th offense notice. His most recent conviction being February of last year, 2023. Some of these are violent offenses, like armed robbery, felonious assault, and the like. In addition to that, I'm told by the people that there's been a violation of this court's no contact order, in that defendant is not to have any contact with the plaintiff witness, either by himself or through any third party, social media, and the like. So, sir, as I deny your request to reduce your bond, you can thank those people who have reached out to the plaintiff witnesses. Tell them it's all their fault that you're still sitting in jail. Bond will continue. Thank you. Mr. Gagnon here? There he is. How you doing, sir?
Happy New Year, Your Honor.
Happy New Year.
No. It's a waiver.
Waiver?
Yes, please.
Andrew Robinson. Calling case 2360334, people of the state of Michigan versus Andrew Robinson. Defendant is charged in count 1 assault with intent to do great bodily harm less than murder or by strangulation. Count 2 weapons, firearms, larceny. Count 3 weapons, firearms, possession by a felon. Count 4 felony firearm. Count 5 unlawful driving of a motor vehicle. Count 6 assault with resisting obstruction of police officer. Count 7 domestic violence. Defendant has a habitual offender section of this appearances for the record.
Good morning, Your Honor. Eric Decker, PA 5931 for people.
Brian Gaggins, your neighborhood defender service, P64220. State your name.
Andrew Robinson. Designated time set for preliminary examination, counsel.
Your Honor, we ask the court to accept my client's waiver.
Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one. It will be bound over to Wayne County Third Circuit Court as you stand charged. You understand? You understand the nature and the purpose of the preliminary examination? Yes. You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit that is probably caused. Is anyone forcing you to waive your right? Is anyone promised you anything? Are you waiving your right of freedom voluntarily? Any objection from the people?
No, Your Honor.
Court finds defendant's waiver was made knowingly and voluntarily free, therefore, full therefore finding the defendant also remain commentary to the court. Criminal position, his arraignment on information date and time will be January 19th, 2024 at 9:00 a.m.
Your Honor, to the bond, he's on a tether, but it's a house arrest tether. He does have work. Is it possible to put him on a tether that allows him to work during certain hours?
Should we work in court on
Please.
give me an order to that effect? I also need you to sign a
record.
waiver.
I'm filling in. Oh, gotcha. Gotcha.
Mr. Washington here on Walker.
No, sir. Mr. Washington's not here. Neither is Walker.
Your Honor, does the court have orders here? Could I use a motion to reduce bond?
Sorry.
Do you have orders, pre-set orders here, or can I use a motion to reduce bond?
You can do a motion to reduce bond.
Thank you.
Yes.
For anything? No.
Get your permission. Get your permission? No, I did not yet. I need it right now. And this is a really slow. Because it's still,
Ms. Brush, what else do you have?
I'm Nandy Long.
Nandy Long?
Nandy.
Okay, let's do Nandy.
She been brought up.
yes.
Okay, if I can talk.
Okay.
And Judge, I do have one witness on that one. She got dropped off at Frank Murphy. She's walking over right now.
Okay.
Yeah.
I have the name, Judge.
Okay, great.
Yep. Never use it.
This is my woman that tried to escape. Tried to escape from the hospital, climbing from the ceiling. Is that her?
Yes. That's not on this warrant. That was pending warrant.
Oh, okay.
But yeah, it's related.
Escape is always relevant. Consciousness. For the people ready on Walter, Sherrod Walker. Hey, how you doing? Happy New Year.
I don't think Mr. Washington's here yet. Was Washington on that one?
Hey, did you have anybody here on Sherrod Walker?
Do I have anybody here?
I do, yes.
Do?
I'll be back as soon as I can.
Yeah.
Yes, I do.
Mr. Gagnon, do you have a way of contacting Earl Washington for me?
Possibly, probably.
You can let him know he needs to get his blood here. We're waiting on. I appreciate it.
No problem.
Man.
That's sense, sir.
Thank you, I appreciate it. I think I need this bigger too.
Okay. 1 and 2 is probably a great day.
Those are my frequent flyers.
Do you need me to contact her?
Yeah, I think we contacted him. Did we contact Mr. Bishop?
Yes, we should.
Did we get Mr. Ray? So
Mr. Ray. Okay. I'll leave that there.
Judge, I'm ready on this one.
Okay. Calling case 2360480 versus Andy Tanika Long. Defendants charged in count 1 home invasion, first degree, count 2 unlawful imprisonment, count 3 unlawful imprisonment. Defendant has a habitual criminal second experiences for the record.
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513. Good morning, Your Honor. Neighborhood Defender Service by Summers Fresh, number 85828. Appearing on behalf of Mandy Long, who is present today. Ms. Long, please state your name for the record.
Mandy Long.
Is date time set for preliminary examination? Are we ready to proceed?
Yes, Judge.
How many witnesses will we proceed?
Just one for the people, Judge.
Okay.
And
Call your witnesses.
before I do that, if I may, I just have a couple of things to put on the record. I would put the court and defense on notice that we may amend based on the testimony to kidnapping under a theory of child enticement. That is NCL 750.350. I also, for the record, have a certified copy of the court order ordering this Long to only have supervised visitation with these 2 children. I would be admitting this under 766.11B as a certified copy of a written court order. And that's all I have. And Your Honor, at this time, people will call Ms. Ashley Long.
All right. You have the witnesses' name.
Yes. At this time, Judge, I would need to admit and publish that court order. But we wait for.
Any objection?
No, Your Honor, I briefly looked at it. What? Yes.
Yes.
Oh, But my last thing for the record is that I had a stand-in OIC today, for Detective Willis. Her name is Detective Kimberly Cochran.
What's the last name?
Cochran, Cochran.
Happy New Year, Ms. Cochran.
Your Honor, happy New Year as well.
Thank you. Any objections to the OIC remain?
No, Your Honor.
Okay. Good morning, ma'am. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat right there in the box next to me. Speaking to that microphone nice and loud so we can hear you, okay?
Okay. Thank you, Judge. Good morning, ma'am. Can you please introduce yourself for the record?
My name is Ashley Horton.
Thank you. And Ms. Horton, do you know someone named Mandy Long?
Yes,
How do you know her?
she's my cousin.
And do you see her in the courtroom today?
Yes.
Could you point to her and tell me what color she's wearing?
Is it greenish, darkish?
Your Honor, the record reflects the witness's identification of the defendant.
So noted.
And thank you. And how long have you known Ms. Long?
We're all my life, we're cousins. Younger as kids, we grew up together.
And do you know her children?
Yes.
What are their names and ages, please?
Krishana Smith, she's 8 months old, and Juliana Smith, she's 3 years old.
And for the record, Christiana is Criseana, and Juliana, Juliana.
Yes.
Thank you. And were the girls in your care on December 13th, 2023?
Yes.
And in what capacity were they in your care? Were you babysitting them or something different?
I took guardianship over them during foster care.
Do you recall when you took guardianship of them?
November 21st.
And is that in 2023?
Yes.
And when you took guardianship of them, do you know if Ms. Long is permitted to have visitation with them?
Supervised visitation.
And do you ever organize that for her?
Yes, it's organized through Orchard Children and Family Services.
And when you have those meetings, are they at your house or are they at Orchard Family Services?
Always at Orchard.
And did you speak to Ms. Long on December 13th?
Yes.
And what did she talk to you about?
The day before she contacted me, she said the girl's grandmother had a Christmas gift for them that she wanted to get to them. Could it be possible just to get the gift dropped off? That was the day before, so that day on December 13th, we set it up to plan to have the gift come to my home.
Okay, I'll pause right there. When you say we set it up, who's we?
Me and I.
Okay, so there was an agreement for her to drop something off to your house?
Well, it was supposed to be the grandmother.
Okay.
Dad and grandmother.
Okay, so was it your understanding that the grandmother was the only person coming over
The
that day?
grandmother was gonna drop the gift off.
Okay, and then did you see Ms. Long that day?
Yes.
Where did you see her?
She came to my door.
And what's your address?
19328 Snowden, Detroit, Michigan, 48235.
And when she came up to your address, was she alone or was somebody else?
Somebody else.
Okay, did you recognize that person?
No.
And did you allow Mandy and that, you said it was a male?
Yes.
Did you allow Mandy and that male to come into your home?
I did open the door, but my understanding I was grabbing the gate, but they did come in.
Okay, and how did they come in?
As I opened the door to grab it, they kind of like just slid in. It wasn't like aggressively or forcefully, through the door.
Okay, were they invited into your home?
No.
Okay.
She had never been before.
And when they were inside, what happened?
Nagi went to, she hugged, Juliana and then picked Krishana up. After that, they both proceeded out the door with both of the girls. I thought it was first just like a hi, hello, like a hug. And then they proceeded out the door.
When they came in, you said they kind of just scooted in. Did they make any physical contact with your body?
No, well, it wasn't like no breaks or anything.
Okay. So once they're inside and they hug the girls, what happens next?
She picked up the baby, Krishana, and, the gentleman picked up Juliana and they proceeded.
And did they say anything to you when this was happening?
No.
And on their way out, did anybody make any contact with your body?
Yeah, like I kind of like tried to stop them because I knew they wasn't supposed to leave and that wasn't an understanding and they still went out the door.
Okay.
Yeah.
I'm sorry, did anybody make any contact with your body?
Well, kind of like, to like push me out the way, like, yeah.
Okay, so kind of on their way out the
Yeah,
door, is that what you're
out the
saying? Okay, and who was that?
The gentleman, he was in front and I followed him up.
Okay. Did they take anything besides the kids?
No.
Did they, so none of their belongings, clothes, food?
The girls had coats on.
Who put their coats on?
I did. They were already dressed. We were already planning to go. So the girls already had coats, but they had no bags or anything.
Okay, so you were already planning to take
Yes.
them somewhere?
Yes.
Okay, where were you guys gonna go?
I had to drop my daughter off at school. It was 7:30 in the morning.
Okay, thank you. And after they left with the girls, did you see what kind of car they got into, or did they get into a car?
They did go into a white small car. I didn't know at first, make or model of the car.
And did they then leave?
Yes.
Did they ever come back?
No.
Did she contact you back?
No, never.
I believe that's all the questions I have. Let's
Cross examine.
So you testified that there was an unknown man with Ms. Longley.
Yes.
And it was your initial impression that this was the father of the girls, right?
Yes.
But you had met him before.
I seen him like far away. When I dropped the girls off for a visit, I give them to a worker. So I haven't only seen him at their supervised visit.
Sorry.
I have only seen him at the supervised visit, but we haven't sat together and had a conversation or talked. It's kind of like I hand the girl to the worker and I've seen him afar.
Okay. And so you thought that was him?
Yes.
And you said you had spoken to Ms. Long the day prior, right?
Yes.
And you've been fostering the children for about a month?
Yes. Well, it would have been almost a month.
Almost a month.
Yes.
And so you wanted to foster these girls, right?
I did, yes.
And you worked with CPS, the caseworker, right?
Yes.
To make sure there was a safety plan in place, right?
Yes.
And you were upset when this happened.
Yes.
Because that safety plan did not go forward as it should have.
Right.
You testified that the man was the one who shoved you.
Wasn't, well, yeah.
Or
you
pushed
know,
you aside, I should say.
Yeah.
You said it wasn't aggressively or forcefully.
No.
Ms. Long was not acting aggressively or forcefully towards you.
No.
then. I can have one moment, Ron. And so you opened the door, right?
Yes.
Ms. Long or the man opened the door.
But I opened the door and then it was, you know, kind of came in.
Oh, understood. No further questions, Karen.
Any reserve?
No, Your Honor.
You opened the door, did you allow them to come in?
No, I thought I was in a gift, but once I thought I reached my hand out, it was kind of like for the spring apart and then it came in.
Is that with your permission?
I didn't allow it because at first I did say no, because I thought it was just a high and hug. So at first I didn't stop it until I realized they were leaving out the door when it was open.
May I ask a question based on those questions?
Go ahead.
When you notice that they're trying to leave and get out the door, how do you convey to them that you don't want them to do that?
I tried to run to the door to stop. I told them they can't stay clean, and then it was still.
You're gonna have to control yourself. Shut up.
I tried to run to the door before they exit out. I told them they can't leave, and it was still like pushed through the door out.
Oh, yeah, thank you.
Anything else, Ms. Brush?
No, Your Honor.
Thank you, ma'am. You may step down. Any other witnesses for the people?
No, Judge.
Any witnesses for the defendant?
No, Your Honor.
People?
Your Honor, the people would move to find over on, I'll tackle the home invasion charge first. I think that's the clearest. These people were not invited into Ms. Horton's home. They pushed their way in and they pushed their way back out. They, working in concert with each other, pushed Ms. Horton. That is an assault that took place in the home that she was occupying. She's lawfully in that home at 19328 Snowden in the city of Detroit. After this happens, 2 little girls are taken from the home. You have the court order before you that they are to be only having supervised contact with Ms. Nandy Long. And albeit Ms. Long decided that she was going to take these children that day and she did not bring them back. She knew she was not allowed to take them. People would move to amend both her counsel and lawful imprisonment to kidnapping child enticement, as she did forcibly or fraudulently take away 2 children under the age of 14 with the intent to detain and conceal such children. She was told repeatedly, don't come over here, don't bring these Christmas presents, we're not doing this way. And she does it anyways. When she does get there with these alleged Christmas presents, Ms. Horton says, okay, bring them on in, say your quick blows, get out of here. She doesn't do that. Your Honor, I believe we've met our burden as to a probable cause statement.
What's the statute?
That statute is 750.350.
Ms. Brush?
Honor, I would object to bind the group here. Or I would object to the home invasion first degree count entering without permission. The people have not proved by standard of probable cause the defendant entered a dwelling without permission, which is a required element of home invasion first degree. Based on Ms. Horton's testimony, she did allow them to come into the house. She said she opened the door and she thought there was going to be a hi and hello, and they entered the home that way. Her testimony also made it clear that there wasn't any forceful or aggressive pushing into the home, which is also relevant when we're thinking about home invasion first degree. And when it comes to the unlawful imprisonment, I also argue that people have not met the burden that the defendant.
You're moving to amend that charge to kidnapping child enticement.
Sorry?
They're moving to amend.
Oh, they're
the
moving
charge
to amend it.
kidnapping, child enticement.
And Your Honor, I object without argument to those charges.
People, let me hear again the home invasion first degree, because the witness testimony was that once she opened the door and realized it was them, she did allow them to come in. But she thought it was going to be a brief hug or whatever.
Your Honor, I would agree with defense on that one then, because at first she did say that she had only opened the screen door and that they pushed in past with that storm door. And then the testimony did develop further that she did allow them that portion. So people would agree that we have not met that element.
All right. So the court, after hearing the testimony of the witness that testified, is satisfied that people have met the burden of probable cause as it relates to the amended charges of count 2, kidnapping, child enticement, and count 3, kidnapping, child enticement. The court is not satisfied that people met their burden of probable cause as it relates to count 1, home invasion, first degree. The court finding those charges were committed in the city of Detroit. The court finding probable cause to believe this defendant committed them will bind the defendant over to Lane County Third Circuit Court Criminal Division for proceedings. Her arraignment on the information date and time will be January 12, 2024 at 9:00 a.m.
Your Honor, may I address that?
You need to waste my time, go ahead.
I just asked for, it's currently $500,000 cash. I'd ask for a reduction to $50,000 10% bond.
Why on earth would I do that? Because I've been watching your client sit here who's been unable to control herself. She doesn't respect the court. Now she can respect the court allegedly when she took the children in violation of the court's order. And then I'm also told that I believe I heard at the last bond hearing that she was hospitalized and tried to escape from the hospital by climbing through a ceiling or something like that.
Oh, no, she has not been charged with that, my understanding yet, but Ms. Johnson did bring it up at the last bond hearing. I also want to reiterate my concerns about Ms. Long's health, safety of the Wayne County Jail.
I'm concerned about her being a flight risk.
Your Honor, I think a GPS tether with house arrest.
People take tethers off all the time.
She gave her mother, who is willing to take her to have her at her home, with still a cash bond. I would argue that that would be sufficient here, to protect the safety of the children as long as.
I wholeheartedly disagree. Please continue.
Thank you.
Thank you.
Thank you, Your Honor.
Thank
Have a
you.
good weekend, Judge.
Thank you as well.
Oh, right.
This person here, dismiss us at count 1.
I just want to, and I just work.
That's all.
Ron.
Hey, how you doing, Your Honor?
Happy New Year, sir. How you doing?
I'm doing great, thank you.
Good. I have to get your autograph soon.
I need yours first.
You're on everything these days.
I'm just a servant.
Mr. Vickers,
Yes, Your Honor.
please tell me why I shouldn't assess you a fine of $150.
Your Honor, I didn't have this on my calendar. It didn't come through the system, Your Honor, through the holidays. I apologize. I didn't know, and I've been on the docket over here at Frank Murphy. I did not. I'm sorry.
I don't understand why it's not on your calendar, it's on my calendar.
Well, I can appreciate, I appreciate that, Your Honor. Mine comes through a different way, so I do understand exactly what the court is saying.
Weren't you present when the date was given?
No, Your Honor, this is a PCC. I was not. These come automatically to us.
It's extremely irritating that not only are you 2.5 hours late, but that we have to call and look for you.
I can appreciate that, Your Honor. I do understand what the court is saying, Your Honor. As I indicated, I didn't know. My office did contact me. I was in court, and the call from the office came just before you saw me log in the first time. And then I had to log right back out. I apologize for having to log right back out.
No mistake about it, I will not be having this discussion again. The next time I have to wait or call around looking for you, I will be assessing the fine.
Your Honor, what I would suggest is if that's the case, the court has the discretion to reassign the case as well.
I can do that too, but I'm still.
Because I'm not in a position to pay a lot of fines, Your Honor, as the court is well aware.
And you need to be when you need to be there, like the other people in your office.
Well, and that's what I'm indicating, Your Honor, and I apologize again, but I don't have total control of that system, Your Honor.
Why is it just you then? Because everybody else appears to show up on time.
I'm not sure, Your Honor, why it's just me. I'm not sure why the court. I'm not sure. I'm not sure. Maybe that's something that me and the court should have a direct conversation about off the record.
Oh, I'm here. We're ready on Reyes. Okay. Your client was sitting here all morning. He's gone now.
Calling case number 230-607-1301. The people of the state of Michigan versus the defendant, Leo Reyes. The defendant is being charged with count 1, criminal sexual conduct first degree, during felony, count 2, controlled substance delivery of marijuana to a minor, count 3, unlawful imprisonment. Defendant is a visual offender for offense notice, mandatory 25 years to 25-year sentence, separate probable cause.
Appearances for the record, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
Excuse me, may I please court, Your Honor, Tyrone Baker, P number 62647, appearing on behalf of Mr. Reyes. Your Honor, I would respectfully request an examine this matter.
Not guilty and set this matter for preliminary examination. House January 19th at 10 o'clock.
Your Honor, my only problem is that starting on Tuesday, the 15th, I start a CSC 1 kidnapping case. That defendant has 4 cases that are each set for trial kind of each following week. I don't anticipate all 4 to go. And quite frankly, there was a time where we didn't anticipate any of them. But long story short is that starting on the 15th, I do expect to be in that jury trial, and depending on what happens, could be in jury trial for quite some time. I, of course, can kind of speak with my office as far as what other accommodations that we can make. So I'm just not certain, Your Honor, what exactly the layout is going to be over the next couple of weeks. And I apologize for that. It's just that I don't expect all 4 of these cases to go, but I certainly most likely will be in trial on Tuesday through that week, which would cover the 19th.
Earl, what do you want me to do?
If the court would set the matter maybe at least the following week, if not the week of January 29th, it would give me some time to that. I do anticipate that even if that first case goes.
No, I'm not going to do the 29th. I'm not going that far.
Okay. If the court would set it sometime the week of the 22nd, that would help me at least see what I can do as far as calendar. And I will contact the court to update about what exactly is happening with those cases. And if I need to get someone else to do the exam or something like that, we'll figure it out. I would obviously, given the charges, I would prefer not to have someone stand in for the exam.
Are you waiving the defendant's presence?
Yes, Your Honor. I would respectfully ask the court to waive Mr. Reyes' presence. It's my understanding he was present in court. And I do apologize for the late appearance.
All right, the court will waive the defendant's presence, continue to plead not guilty, and set this matter for preliminary examination on January 22nd at 10 o'clock a.m.
Your Honor, is it possible we could do the 23rd or any other date after that? Just because the 22nd would be the start date of the trial, and I just don't know what's going on.
Start date of what trial? I thought your trial started the week of
this defendant has multiple cases that are all set back to back to back to back each week over the next 4 weeks.
Sounds like your office may need to reassign this case. If you're tied up for a month.
You're talking about the case before you, Your Honor?
Yes.
I understand. And if that's what happens, that is what we will do.
All right, so I'm going to leave it on the 22nd at 10 o'clock because your client is also in custody. I don't want to put it any further out.
Understood. Understood, Your Honor. 22nd.
Judge, if I may, I know that defense counsel has some obviously trials. I do have one set for the 22nd. I don't know if that's for sure going to go. I did just want to make the court aware of that.
Well, you may have to reassign yours as well, Mr. Like I said, this gentleman in jail.
I mean, to be fair, I'm aware, Your Honor, and I wouldn't have been available on the 19th, so I just would let the court know that. So,
Mr. Bigger is not going to be available on the 19th.
I know, I'm aware. Thank you.
All right, 22nd at 10 o'clock. I'll continue.
Thank you, Your Honor.
Mr. Washington here yet?
No, sir.
Mr. Brown is here.
Yes.
Come on, Mr. Brown.
All right, thank you.
Hey, Brandy Williams.
Yes, good morning.
Good morning, happy New Year.
Happy New Year.
Calling case 2360555, State Michigan versus Brandy Capri Williams. Defendant is charged with count 1 assault with a dangerous weapon, count 2 felony firearm, count 3 domestic violence. Appearances for the record, please.
Good morning, Your Honor. Eric Decker, PA 59313. And good morning, Your Honor. Brian Brown, PA 0560. Appearing on behalf of the Randy Williams, who is present. Ms. Williams, please state your name.
Brandy Williams.
It is date time set for preliminary examination. Are we ready to proceed?
Yes, Your Honor. Yes, we are.
How many witnesses will be?
One, Your Honor.
Okay, call your witness.
Your Honor, the people of Tyrese Miles.
Ma'am, please give your name and the spelling of your name. You have it? Okay, please raise your right hand. You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. Please have a seat. The witness box right next to me. Keep your voice up nice and loud and speak into that microphone that'll be to your left. You may begin when you're ready.
Thank you, Your Honor. Good morning, please restate your name for the record.
Hi, Ms. Miles.
Ms. Miles, now, do you remember the date of December 19th of 2023? Now, I'm going to give you a location. It's 11330 Stockton in the city of Detroit and County of Wayne. Does that sound familiar to you?
Yes, Stockwell.
Stockwell? Okay. Now, now why does that sound familiar to you?
That's my friend's house.
That's your friend's house? Who's your friend?
Do I got his name?
Oh,
It's a close friend.
a close friend. Fair enough. All right. So do you remember something that happened on that day on December 19th at that address?
Yes, I do.
Okay. Now, is there anybody in this courtroom that you remember from that location on that day?
Yeah.
Okay. Could you maybe point them out? Something that they're wearing?
I was the teacher that came to
Okay. All right. Like let the record reflect that the witness has identified the defendant. So on that day, where did you see the person you just identified the defendant? Did you see that person at that location on that day? I'm sorry if I asked that already.
Later on.
So you're saying that you did see her at that?
Yeah.
Okay. So when you saw her, what was she doing?
Kind of like my face.
Okay. Okay. So how do you know the person you just identified was doing that?
And we worked together as
7 years. When you say work together, where do you work together?
No, like in a relationship.
Yeah, in a relationship.
Yeah, we were in a relationship on and off for like 7 years.
So like,
We still live together right now. But we are in a relationship. So I don't know.
I apologize. Now, did you see her at all before the incident? The thing that you're describing is the incident. Did you see her? Yes.
No, I didn't.
Did you see her anywhere that day?
No, I didn't.
Okay. What was before the situation in Stockwell, had you had any conversations with her?
Yeah, for me to come home.
Okay. Why?
Because I haven't been here.
Okay. Haven't been there.
I haven't been home.
Okay.
I'll be home later.
Okay. So why did you go to Stockwell?
Well, that's just like a place that we all, her cousin, it was I hang with her too outside of Brady. So we were all just over there, just hanging out, chilling, playing cards,
Okay.
the usual, was nothing like that.
Okay. Well, you keep referring to this to something as the incident. Where were you when this incident started?
I was in the car.
It was in a car. Could you describe the car for me, please?
So like 2019.
Okay. What time was it? Was it night?
Yeah, it was
Okay.
dark.
It was dark.
Maybe, I wanna say like 11 something, if I'm not mistaken, when it first started.
Okay.
Yeah.
Okay. So how did it start? What happened?
Well, it was a third party situation that had nothing to do with Brandy, and me not knowing that they reached out to one another, I was leaving. Me and her cousin, like, we were leaving, and I was.
You were leaving where?
From off Stockwell. I was
Okay.
getting ready to go home.
So you're sitting in your car
I'm
and
walking to my car.
walking to your
As
car.
I get into my car, I recognize that I didn't have my phone or anything, so before I could open the door, Brandy is opening for me with the gun pointing in my face.
Okay. Where was she while you were opening the door?
Standing outside the driver's door.
And what side are you on?
I'm in the driver's seat.
You're in the driver's seat.
Mhm.
And while you're sitting inside, so you were sitting inside the car? So then, who opened the door?
Brandy.
So she opens the door from the outside?
Before I could open it, she was already open.
Okay, so then, after that, what happened?
She hit me in the back of the head with the gun.
I apologize, let's go back. So you look over, you're sitting in the driver's seat.
Yeah,
Do you look to the left?
I look to the left and recognize that the gun is pointed in my face.
Okay, so how far, so where is the gun?
Like right here,
Okay, well, you're holding your hand up.
like right here.
Would you say that's 3 inches?
Yeah.
Okay, how close was the gun to your
It
face?
was like literally like in the center of my face.
In the center of your face? Okay, so did you see, what did the gun look like to you?
It was like a black gun. I'm sorry.
Take your time.
It was like a Glock or something. I'm not sure. I'm not good with guns.
Okay.
But it was a black gun. They had like an extended clip on it or something. I'm not sure. Yeah.
Okay. But you're sure that it was a gun?
Yeah.
Okay. So then when you see the gun pointed at your face, then what happens?
I didn't know it was Brandy until I actually like took my time, like looked back, and I'm like, wow, like what are you doing? Like, you know, like why do you got a gun? What are you doing? And she like, bitch, you think I'm playing with you, bitch? And she hit me in the back of my head with the gun.
Okay. Now, when you say that she hit you in the back of the head with the gun,
Mhm.
what part of the gun hit your head?
And she had the gun like this and hit me in the back of my head.
Okay, so what would, all right, so
So I'll say like
let's agree that the part that you
five,
hold is like the
So she
handle.
holds it like this, and when she hit it, it's still like this.
Okay.
So it's like the end, like the back towards the back of the gun, she just like smacked me back in my head.
The part that you hold?
Like the whole, like the gun part, the back of the gun,
Okay.
like when you like pocket.
Yeah.
The butt of the gun or the barrel of the gun or the butt
Like
of the
the
gun?
barrel, like the whole side, it was just like she smacked me back in the head.
Okay. Now, where were you when now you say she hit you in the back of the head? Where? On the
Right here,
Okay, so in the center?
like the left side, or my left and right.
Okay. Okay. Okay, so she hit you in the back of the head with the gun, then what happened?
She's acting like speak on when I'm trying to get off the car. When I'm getting off the car, she shoots the gun in the air like 4 times, maybe. Blah, 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 blah. Her cousin run and jump in front of the gun and tell her like she not about to let her gun
Objection
walk
to,
away.
objection to whatever her cousin said.
But,
Okay, let's just go back. So, where are you? So your testimony is that she fired the gun.
Yes.
And your testimony is that you fired the gun that she fired the gun 4 times.
Mhm.
Okay, so where were you while she was firing the gun?
And in the middle of the door, like I wasn't outside the door yet. I was standing outside the car, but I'm still inside the door. It makes sense.
Okay. So the door's open and you
Yeah,
have
and I'm
closed.
standing, yeah.
Okay. Okay. And so when you heard the gun, so you're sure that you heard it 4 times?
Yeah.
Okay. So then based on that, what did you do?
I was stuck. I just really couldn't do nothing. I was already in the middle of the door. She was standing right there. She pointed the gun at me again. And I was just telling her, like, you know, the police is gonna come. Like, what are you doing? What are you doing? Like, this time you might be like, you don't even do stuff like this. What are you doing? I'm just talking to her. And she just keeps saying, fuck you, bitch. You got me fucked up, bitch. And I hate you and all this and that. Then when the police finally come.
Okay, let me come back a little bit. So after she's standing there with the gun and she's saying those things to you,
Yeah.
does she do anything after that?
Yeah, she punched me in my mouth. My lip was busted. I got it on this picture.
Okay, no, it's okay. So she hit.
Punched me in my lip, and then she went when she ripped with her cut after the gun was taken away from Brandy. Before the gun, I'm sorry.
Who took the gun away from Brandy?
Alexis Wood,
Okay,
which is her cousin.
okay,
And then before she took the gun though, Brandy went and bust out the window on the house, on top of at my friend's house.
so where were you when that, let's just kind of come back. So after she fires the gun, then
They were on side of the house.
what was the next thing that she did after she fired the gun? Hit
She
you?
bust out she hit me and then bust out the window.
Let's just go sequence, like
Okay.
order at a time. So first she,
Hit me.
okay, then after that,
She bust out the window,
which window?
the front window.
So was she walking away from you to do that?
No, I was trying to like walk away from her,
So, okay, so where were you walking when she did
like
that?
in the front of the house. I was trying to like, I was scared. I didn't know.
Okay.
You know, I've never been in a like that before.
Okay, so you're trying to go back to the house and then then your testimony is,
Hitting on the window, like, open this motherfucking door with the bottom of the gun,
okay, and at that point, what happened?
the window break.
Okay, so now we have the broken window, then after that, what happens?
Alexis takes the gun and I don't know what she did with it.
Okay. So then, after that, what's the next thing you remember?
The police came, she get to try to tell the police that I stole the car because it's in her name.
Who called the police?
I called the police.
You called them? When did you call them?
In the midst of all of that happening, but we already heard the sirens coming.
Okay.
The area is like a limit of where I guess they do a lot of shooting at, so.
Okay.
It's like a target or some type of thing, like they're recognizing where the siren is coming from.
Okay. Okay, nothing further. Thank you.
Cross the line.
Good morning.
Good morning.
You stated that you were over your friend's house, correct?
Yes.
Okay. And you were reluctant to give that friend's name, right?
What does reluctant mean?
Oh, you were hesitant.
I wasn't hesitant, I just want to know if I need to.
Yes. What's the friend's name? I want to know.
Is that a part of the case?
Yes, it is. I asked you a question. It's part of the case, yes.
Yes, ask the question.
Okay, his name is Wayne.
Wayne what? Wayne Jr.? Okay. Now, isn't it true that you witnessed Wayne Jr., that's his name, and other individuals rob Miss Williams of her belongings?
No. No one.
You remember you're under oath?
Okay, I'm under oath. No one ever robbed Randy. Randy came over in a.
Okay, so you're saying you did not see after the window was broken, they didn't come outside and demand money?
No one did anything. Randy didn't have any money on her.
That's not my question. Hold on. Let me ask my question.
Okay.
My question wasn't whether or not she had money on her, that they took her belongings from her, i.e. her cell phone.
No, she dropped it and ran.
She dropped it and ran. Okay. And you were present when they picked it up, right?
I picked it up.
Oh, you picked it up?
I told her cousin that I
Okay,
had her.
okay. You picked it up?
I definitely did.
Okay. Now, isn't it true that you've been cash apping money from her phone to you?
No, I mean, Randy sent me money all the time.
No, that's not my question. That's not my question. I'm asking.
Okay.
Isn't it true that you have used her phone to cash app money from her phone to yourself after this incident?
No.
You haven't?
Well, I did, I did one time.
Okay.
For stolen.
Okay, thank you.
I do admit to that.
Thank you.
I did.
Oh, okay, thank you.
You're welcome. I'm sorry.
And isn't it true that you had her car on that day for about a couple of weeks? You were supposed to go to the store, ran off and had her car for multiple days, if not weeks, prior to this incident. Yes or no?
No. No.
Isn't it true you did not have permission to have her car on that day?
No, sir.
No, you didn't have permission?
No, I haven't.
Just should ask, answer.
Thank
And it's true that you reside at her house, or you used to reside at her house, right?
That's our house, yeah.
The mortgage is in her name, right?
Yeah, but
The mortgage is in her name, right?
Yeah.
Okay.
Can you let her answer the question?
I'm sorry. I'm sorry. None of the utilities are in your name, correct?
In my name?
Yes.
No, it's not.
This vehicle was in her name, correct?
Yeah, because I don't have license.
So you were driving the car with no license at
Yes, I was.
You stated that you go over to this friend's house, I guess his name is Wayne Jr., to drink. You were drinking that night?
We were all drinking.
Were you?
This is somewhere we hang out at. It's not like I was just there. It's just somewhere we all hang.
Listen to my question. Were you drinking that night? Yes or no?
I think we had just started drinking, if I'm not mistaken.
You?
Literally.
I'm talking about you, nobody else.
I'm telling you my answer. Sorry, sir. We had just got from the store. We had just started drinking, so it wasn't like nobody was intoxicated.
What were you drinking?
I think we had some. I can't think of the name of it, but it was a tequila.
Had you smoked earlier?
No. I had stopped smoking, but I have a drug test for my job.
Okay. Are the windows tinted on that vehicle?
The driver one, the two back ones, the back windshield, the passenger, window isn't tinted.
So the driver window was tinted. Okay. And what time of day was this? Was it nighttime?
Incident was happening?
It was a nighttime.
Yeah.
Okay. So from the outside, a person can't see into the driver's side window because of the tinted windows, and it was dark outside. You would agree to that, correct?
Referring to what though?
If you're outside the car, looking in the driver,
That's not how we.
that's not what I'm asking you.
Oh, no, you can still see through the tent. It's not like it's 5% tint. You can still see in and out the car.
You can?
Anyone can.
Oh, you can't say what anyone can. Okay, you can. Okay. Thank you. So when did you get permission to get this vehicle?
I have my own set of keys to the.
That's not my question.
I'm giving you my answer, sir.
Objection, that is an answer to the question that she has her own set of keys to the answer.
The question was,
when did she get permission to drive this car on that day?
I have my own set of keys.
question is, when did you get permission?
I mean, I've always had permission. I don't never ask. I
Okay,
just go.
just answer that question. She said she's always.
So how long did you have the car in your possession?
Well, we got the car in August.
No.
I've always had the car. I can't give you a specific time. I always have the car. I always have it, but she worked from home, so.
Okay, when did you leave her house with the car prior to this incident?
It's probably been like 2 weeks, like a week and a half.
Yeah. So, okay, so let's get this straight. So my head, I'm kind of confused. So what you're saying is, you took the car from her house.
No, I was home. I drove the car to the city.
And you had it for 2 weeks.
It was my vehicle. The situation happened to where all four of my tires got stabbed up, and Brandy knew about that as well.
Okay, that's not my question.
So I'm talking, you asked me a question, I'm just giving you my answer, that's all. All four of my tires were stabbed, I didn't have any money at the time to get my car.
I didn't ask you that.
I didn't take any tires. You asked me, why did I have it that long?
No, I didn't ask you, I said, how long did you have it for?
Oh, okay, well,
Right.
yeah, we get almost 2 weeks, yeah.
Okay. Do you know if Brandy has another car?
We don't, doesn't get repo.
Okay, so you took her only car that's in her name and had the car away from her for 2 weeks, correct?
It's our car.
Is this car in your name?
I don't have license, so there's no way it can be in my name.
That's not my question. Is the car in your name, right?
It's not, because I don't have license.
The car's in her name, correct?
It is, but she has license.
And approximately what time of day was it? You said at nighttime, but what time of night was it?
That the incident happened,
Yeah.
or did I leave from home?
That the incident happened, I'm sorry.
It was like 11 something, it was dark, it was like almost midnight, it was late.
Now, when you say that her cousin allegedly took this gun from her, this was when you were inside of the car's door?
No, it's not alleged that she took it, I was right there.
So you were in?
I was standing next to her when she took it.
Okay, and how long after her arriving on the scene did this happen?
Like, she got out the lift and ran up to my car. It was a matter of seconds, it wasn't like,
Okay.
you know what I'm saying?
Okay, and then her cousin came out?
Her cousin was there with me, we
Okay.
were there partying, we were having fun, we were
Okay.
hanging out.
Okay, then her cousin took the gun from her, correct?
After she shot the gun, yeah.
Okay, then you got out the car, right?
No, I was already out the car, sir.
Okay, but you started to walk towards the house, correct?
We were standing on the side of the house when all this was happening. We were
Where was
standing
the car
outside.
parked at? Where was the car?
The car was in the driveway,
Okay.
right on the side of the house.
Okay, and you were, because you said the door was open, so you were in between the door and the seat, correct, standing up?
Which part are you asking me about?
When she came up to the car,
When she came up to the car, I was sitting in the car, I was
Yeah.
in the driver's seat, I realized I didn't have my cell phone.
Okay.
So when I went to go to open the door, she was yanking the door open, or she was already opening the door for me, aiming the gun in my face.
Okay, and then you at some time shortly after you stood up in between the door
After
and the
she hit
seat?
me in my head
Okay.
and pointed the gun and I realized who she was, yeah, I stood up and I was standing in the middle of the door. Say, this is the door that's open. When you open up the door, it swings out like this, right?
Yes.
So if she's standing right here, I'm standing in the middle of the door and the car. She's right here,
Okay.
right here. So there's no way I can just like get away.
I understand. I understand what you're saying. And then after that, you said she shot in
She
the
shot
air.
the gun.
And then after she shot the gun in the air,
Her cousin jumped on the gun and told her that she's not about to let her throw her life away.
and then her cousin took the gun from her, right?
After she busted the window, yeah.
So her cousin jumped on the gun and did what?
Brady never let the gun go. She never let the gun go. She never let it go. She still held on to it. Then she went to the front, hit the window, boom, 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 and it buzzed. I'm telling her, it's kids in there, Brady. It's kids in there. I don't give a fuck. I don't give a fuck. Boom, 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 and the whole window crashed out. It broke.
And then how many people came outside after that happened?
After what happened? After the situation?
After the window broke.
It was my friend.
Your friend who?
My friend Wayne.
Your friend Wayne, okay.
His little brother, which is his little brother is only like 11 or 12, and his nephew was there. My cousin Marquis.
How old is the nephew?
He only 4 years old. My cousin, which is Alexis Williams' boyfriend, they date each other. It was me, Alexis, and my cousin. We all was walking out at the same time. We didn't even know Brandy was there. Nobody knew where Brandy came from. We just knew that she got out of an Uber.
Okay. So after the window broke.
Alexis take the gun.
Okay.
And she do whatever she do with it. I don't know what she did with it.
Okay, and then some individuals came outside.
They was they was already outside. When Brandy first came, when she first came, they was trying to get her. They like, what is going on? She pointed the gun at him. I was like, get the fuck back. She pointed the gun at my friend. Said, get the fuck back. And he like, wait a minute.
Okay. So when the individuals approached her after the window was broken, correct?
No, that was when she first ran up on me. So, okay, listen.
Hold on, who approached her?
You confusing me a little bit.
Yeah, you confused me.
So, when she first came, my friend, we were already walking out the house. Me, Alexis, Marquis, Wayne was closing up the store. So when he seen Brandy running up with the gun, he tried to run down and see what was going on. She turned around with the gun. Mind you, there's no firearms or anything in his house. He's on probation. There's nothing like that over there. He's already on probation, so he's just trying to figure out what's going on. When he running towards the car to see what's going on, Brandy pointed the gun at him and told him get the fuck back. Then she comes to my door. When my door already open, the gun like this, he right here. He's trying to see what's going on.
Okay, hold on, back up now. That's not what you said earlier. So now you're saying your door was open?
When Brandy first pointed the gun in my face, guess it was.
You said she yanked the door open.
She did yank the door open. I just said that.
If it was already open, how did she yank
I
it
said
open?
when the door was open, he was trying to come up and see what was going on. She turned and pointed the gun.
That's not.
Yes, I did. You asking me questions and I'm telling you, sir.
So you didn't say during direct that you were in the car with the door closed, then she opened the door and put a gun in your face. You didn't say that?
Yes, I did say that.
Okay, but you just got done saying, hold on. So you just got done saying right now that you were walking to the car, she was running up,
No,
pointed
I
at.
didn't. I said I was sitting in the car.
Okay.
Brandy was running up. You asked me who came out the house.
Let me talk. So I can be clear in my head. I wasn't there. I'm trying to be clear. Correct me if I'm wrong. You just stated that she ran up out of an Uber, pointed a gun at somebody else. The door was already open, and then she pointed the gun at you. You just said
That's not what I said. I said she pointed the gun at him. My door was open, meaning that she had already pointed the gun in my face. If I just said that she opened the door, that would be the only way she could be pointing a gun in my face if my door is already open. You asked me who came out the house. I said the man who stayed there at his house.
Are you still living at Brandy's residence?
That's my house. That's where I reside there as well. Yes, I do.
Did you pick up any of her credit cards?
She never had any credit cards.
Okay, okay.
Never had any credit cards. She don't even carry cards.
Okay,
She got everything.
Okay, thank you. No further questions.
No, Your Honor. Thank you, ma'am. You may step down.
Thank you.
Oh,
You're
never,
done.
never. I was talking to the judge, but okay.
Ms. McCoy. Roger McCoy. Any other witnesses for the people?
No, Your Honor.
Any witnesses for the defendant? People?
Your Honor, the question of fact has been established. The people request bind over on counts 1, 2, and 3, and reserve time for argument.
Mr. Brown?
I know prosecutors indicated as a question of fact. I would say her testimony is a little bit incredible. And she has a motive, in my opinion, to see Ms. Williams locked up.
Tell me why it's not a question of fact to be determined by a trial.
Your Honor, I just wanted to put on the record that she has some inconsistencies on what she stated. Originally, when she stated that she was in the car with the door closed, my client came up here, opened the door, put the gun in her face, then yanked open the door. Then later, she told the story again, stated that she was walking to the car, got in the car, the door was open, pointed the gun at somebody else, and then pointed the gun at her. Like, that's inconsistent. If the door was open, which she indicated the second time, how did my client yank the door open? And then she tried to reform it a little bit, but it just didn't make much sense. And she doesn't want to tell the truth as far as the incident, where I believe my client was robbed of her property on this particular day. She indicated that, in fact, she did cash.
Let's say for the sake of argument, your client was robbed. Does that give you justification?
No, but it might give a person justification to lie to say that somebody pointed a gun at her, so her and her friends won't be implicated in an armed robbery, which is a little bit more severe, capital case, may I add, a little bit more severe than a felonious assault. So that would give an individual a bias and a reason to fabricate.
The problem with that is I have no evidence that anything like that took place.
Understand.
Secondly, why wouldn't that be a question of fact to be determined by a trial?
I understand, and Your Honor, you're at this point in time, you're the fact finder as far as determining whether or not there's probable cause, and that can be determined based upon a witness's credibility and a motive to fabricate a story.
Let me save us all some time here. I didn't find anything inherently incredible about the witness's testimony. In fact, I thought she testified quite consistently. There may be some other things, or she may not be the ideal witness in that, she has some culpability here in things that she may have done to the defendant as far as taking her money, taking her car, that type of thing. But as it relates to the charges contained in this complaint warrant, that's all I'm here to determine, is whether or not people have met each and every element contained in the complaint warrant. These charges that have been lodged against the defendant, and I find as such, both sides of the defendant have met their burden of probable cause as it relates to the charges contained in the complaint warrant. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this complaint committed. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for the proceedings. Her arraignment on the information date and time will be January 19th, 2024 at 9:00 a.m.
All right, thank you.
And you're no contact with the complaining witness by way of you or any third party, understand? Okay.
Your Honor, it has also been brought to our attention, it has also been brought to our attention just this morning from a complaining witness that there was an attempted contact, I apologize. There was an attempted contact between the complaining witness and the defendant. Also, on a text message that okay.
So now I'm going to ask you, before I delve any deeper into this, did you contact the complainant by way of text message?
This is, I can't hear anything.
Simple question. I don't want to hear all that. Did you contact her by way of text message? You did not. So she's not going to be able to show me a text message if you contact her. Okay. We'll see. And let me,
I screenshotted her.
and let me tell you before we go any further, I don't like being lied to. That's the worst possible thing you can do at this point in time. All right, now let me remind you, you're still under oath, okay?
Yes,
Were you contacted by the defendant?
yeah, she texted me from a random number. She the only person called me Teacup. That's a special name that she called me. And she texted me and said, I love you, Teacup. I said, who's this? She said, I miss you, Teacup. I said, who is this? She never texted me. I told her.
But you know who it was, why did you say, who is this?
Because I wanted to see if she was gonna say her name. She knows she's not supposed to have no contact with me. I had already talked to the prosecutor. She was already threatening me third party through someone else prior to that.
You call her Teacup?
No, I never contacted her.
That was my
No,
question, let me try it again. You don't call her
No, I
Teacup?
never
I
contacted
have
her,
to,
no.
I have to.
You're not listening to the question.
Yeah. Her name is Tyrese, or it's Reese Cup, Teacup, but
Do you call her Teacup is my question.
yes, I call her that from time to time, but I didn't contact her. I promise you I didn't, I promise you. I'm not trying to build my life away from her, I never.
Screenshotted it if you wanna see it. She be texting from a text now. She got fake apps on her phone.
Let me see.
Sorry. And I also called the prosecutor, let her know this was beforehand, that was way before that.
I call that.
Okay. Oh, yeah, she did something, it's not this one, this one. But this is for sure a text from, app. First, probably deleted it by now.
And Your Honor, I'm just sorry, we just have no, this is allegations from her, where she thinks we have no evidence whatsoever there that she's the only, my client, the only individual who calls her Teacup. Your Honor, we have no indication whatsoever that this is my client's phone number. She's just speculating that this is her phone number and that she blocked it and so on and so forth. And earlier she indicated that at the probable cause conference that a third person, I guess they all know some of the same people, reached out to her, wasn't from my client at all. You know, my client didn't tell anybody to, you know, contact her, or I think they just know the same people. So I'm not sure who this individual is, Your Honor. My client knows.
How many other people call you Teacup?
She's the only one. I promise. I'm not lying. Right hand of Jesus. She's the only person calling me Teacup. I promise you. On my father. And he's deceased.
Yeah, that means, I mean, for whatever that means, I mean, you know, people lie all the time. Your Honor, I just know my client, me and her has talked about, she's expressed to me without me having to say that I can't contact her. She wanted me to reach out to the prosecutor and to see if she could go back to her house because she didn't even want to drive by there, didn't want to contact anybody. So she understands that she's not to reach out to the complaining witness through a third party, through a text message, through a smoke signal, through a Morse code, or any form of communication. She understands that to the T, Your Honor. And I genuinely believe that she didn't contact me, Your Honor. Whatever that's worth.
Let me tell you what I genuinely believe. I genuinely believe that she did in fact contact, given that she calls her Teacup and she tells her, I love you and I miss you on the day of her preliminary examination. I fully believe that. I believe that she did. And you are playing games with your wife.
That's what I'm saying, I wouldn't do that, I have a future, I'm not trying to risk it, I wouldn't do that.
I think you did. I think you did. You can step down.
And Your Honor, it's just, we just have no way of proving that. And Your Honor, we're just asking you to give my client the benefit of the doubt. If anything, like, I mean, this could be from what I know about this case and everything didn't get involved, I mean, I would say that she's less than truthful, she's somewhat deceitful. I'm not saying that she sent her own self that text, but it wouldn't be past I guess, my imagination to contemplate that I'm not saying she did, that the complaining witness sent it herself. All I'm saying is, Your Honor, we have no evidence whatsoever other than speculation that Ms. Williams was the individual who sent the complaining witness this text message I guess, today.
Now, the only thing that I do notice in this so-called text message is that I see, "I love you, Teacup, and I miss you, Teacup." Complaining witness said that she responded, "Who is this?" I didn't see that in it. Okay. So,
It was more like, I'm honestly, that the judge told me if I have contact or anything with her, that I will go back to jail. I'm in school and I have a job. I'm not, and I have a house. I'm
just
not
make
trying
sure
to
that
do
you don't, and understand that if you do, she's gonna tell.
Yeah,
And
I'm
then
not, this is not.
that'll be lights out. for you.
Yeah, she told last time. She told last time when it
Well, I'll
was.
continue. Have a
Okay,
nice
thank you.
day.
Thank you.
Mr. McCoy, what can I do for you?
Oh, yes. Good morning, Your Honor. I'm here on Daniel Goldman. We were up yesterday and we set it for an exam for January 17th. And Mr. Goldman said he was on the Zoom, but he was on till 2 or something. And he called me this morning about addressing the bond. I did reach out to Ms. Drain about this issue. So he's wanting to modify the bond. He's under house arrest so that he can go to work and take the kids to school. He wanted to just, I mean, I was trying to see if we could have no assaultive contact, but I mean, Ms. Drain can address that. It's my understanding that the complainant doesn't want that.
Where does he work?
Let me see, I have it in my notes. He works at, where did I put that?
Come on, Ms. Barnwell.
Yes,
You're up.
thank you.
I wrote it down. Oh, here's, okay. Like I got all these files. Yes, he works at Venture Graphics, LLC. He has an apprenticeship. Yeah, he and the complainant, that's his wife. They've been married 7 years. They have 2 children together, 2 young children, 8 and a 4-year-old that he normally.
I just asked you where he worked. I'm not sure why you're telling me all of that.
You know, I'm ready.
So, Ms. Drain, do you have any problem with the defendant being released from house arrest so he can go to work?
I have no objection to that. I did call the complainant. I spoke with her. She has no objection to that. She also indicated that normally he takes their kids to school. And she doesn't have a problem with that continuing either.
All right, so why don't you guys get together on a stipulated order and send it to the court. Send it directly to me, Mr. Court. And Ms. Drain, send it directly to me, yes.
Okay, so stipulated order. So, and we're just saying he's permitted to go to work and take the kids to school.
Yes.
Okay, and then, Your Honor, can you tell me where would I email the stipulated order?
Kenneth.King at 36 District Court.
Okay, Kenneth.King. I'm sorry?
.org. Kenneth.King at 36 District Court.org.
District Court.org. For the 36, is that spelled out or is it 36th?
36th.
Okay, all right. I will put something together and email it to you and Ms. Drain. Yeah, and I hope you and your staff have a great day, and Ms. Drain as well.
Thank you.
Mr. Washington.
Thank you.
Mr.
Yes.
Washington.
Yes, Your Honor.
She assess you a fine of $150.
Oh, Your Honor, I apologize.
That's not the reason.
Okay.
You always apologize, and we always go through the same thing. You and Mr. Vicker, I have the same issue with every time you have a case before me.
All right. You want me to bring it to court today?
So you don't have a good reason why I shouldn't assess you $150 fine.
Judge, I apologize. I mean, I thought I caught myself making putting my cases on the calendar. For some reason, it wasn't on my calendar. I mean, it was
I don't quite understand that, because you show up for the probable cause conference, although you show up late. You show up and I give you the date and you agree to the date, and then you don't show up. And we have to call around looking for you, adding insult to injury. I'm sick of this. Hello, are you there?
I'm here. I hear you, Judge.
So as it relates to you and Mr. Vickers, the next time that you are late, I'm going to assess you $150 or you're going to spend some days in the Wayne County Jail. Understood and agreed?
Yes, Your Honor.
All right. Calling case 2360542 for the state of Michigan versus Sherrod Walker. Defendant charged in count 1 home invasion, 2nd degree, count 2 weapons, firearm, possession by felon, count 3 aggravated stalking, count 4 felony firearm. Count 5 felony firearm, count 6 felony firearm, count 7 felony firearm, count 8 malicious destruction of personal property less than $200. Defendant has a habitual offender for defense notice. Appearances for the record, please.
Good morning, Your Honor. Eric Decker, PA 5931. Let me just check the road.
Mr. Washington, go ahead and check.
Good,
Go ahead and check.
good morning, Your Honor. Earl Washington on behalf of Mr. Sherrod Walker.
And where's Mr. Walker? Are you Mr. Walker? Where's Mr. Walker? Is Mr. Walker in custody?
That's what I'm trying to find out. I'm gonna call him up. Yeah, get him up, Judge.
He's here.
Yeah, I think they sent him back down because we waited so.
Do we have a witness in this case?
Yes.
Mr. Washington, why are you on my Zoom instead of being here?
Judge, when I spoke to the officer, she told me to Zoom appear on Zoom. I can come down to the court, Your Honor.
I think you need to do this, sir, like now.
Okay.
Okay. Is this Mr.
All right.
Washington?
I'll be down to court. Give me about 15 minutes.
Calling case 2360499, people of the state of Michigan versus Michael Jerome Watkins. Defendant is charged in count 1 and 2 assault with a dangerous weapon, count 3 and 4 felony firearm, count 5 domestic violence. Appearances for the record.
Good morning, Your Honor. Eric Decker, PA 5931 to the people.
Good morning, Your Honor. Wendy Barnwell, people 2505, on behalf of Mr. Watkins.
Mr. Watkins, tell us your name for the record, sir.
Michael Jerome Watkins.
There's the date and time set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
How many witnesses? One. Call your witness, please.
Your Honor, the people call it Mr. Rafa Watkins. QUINTILLA.
Watkins.
WATKINS.
Thank you.
Ma'am, please step forward, raise your right hand. Come forward, ma'am. Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat in the witness box next to me. Keep your voice up nice and loud and speak into that microphone that'll be to your left. May begin when you're ready.
Thank you, Your Honor. Please, good morning. Please restate your name for the record. Now, Ms. Watkins, if I say, sometimes I speak too fast. If you need me to repeat anything, please ask. So do you remember the day of December 16th, 2023? That would be actually the last one.
Yes.
Okay. Now, I'm gonna give you a address, that's 17320 Mansfield in Detroit, in the city of Detroit, and County of Wayne.
Yes.
Do you recognize that address?
Yes.
What is it?
My house.
Your house? Okay, so were you at your house on the day of December 16th of 2023?
Yes.
Okay, was there anybody in the courtroom that you see today that you recognize from that day in that location?
Yes.
Okay, could you maybe point them out to the court and tell me something that they're wearing?
Yeah, new one.
Could you be a little more specific, like what color is it?
He got on green.
Okay. Your Honor, may the record reflect that the witness has identified the defendant.
So moved.
Okay. So on that day, why did you see him there? Why were you seeing him at your house that day?
He lived there.
He lives there?
Yes,
Who is the defendant to you?
my husband.
Okay. So on that day, was there any kind of anything happened that might bring you to court today?
Yes.
Okay. What happened?
He was drinking, we started arguing.
Let's stop for just 1 second. Now, when you say that he starts drinking, what is that in the morning? Is it in the afternoon?
Afternoon.
Is the afternoon, like, give me like about what time?
Wow.
Okay. Now, when he's drinking, what is he drinking?
Liquor.
What kind of liquor?
Parmesan.
Okay. Okay, so then when he started drinking, then what happened?
We started talking violent. Then when I was doing me and stuff.
Okay, so how long after he started drinking before he said those things to you?
How long? That's all day, all the way to night.
Okay, so you approximate that he maybe started drinking around 2. What time did he start speaking to you in the way that you just described?
When he started drinking, he started speaking violent.
Okay, when you say speaking violence, what do you mean?
Started speaking like, saying nasty names to me, call me on my name.
Forgive me, but like what kind of nasty things? Like what is that?
Bitch, award, you ain't shit. That's all kind of things.
Okay. So then after he starts calling you those names, did anything happen after that?
No, he just saying what he gonna do to me. He threatens me, say he gonna kill me, then kill himself.
Okay. Now, so at any point, what did you do when he started doing that?
I was laying on the couch, trying to ignore him.
Okay.
Then he
Were
came.
you awake? I mean,
Yeah, I was awake.
okay. How are you laying on the couch?
I'm laying on the couch, the long way, looking at TV.
Okay. Looking at what?
Looking at TV.
At the TV?
Yes.
Okay. So you're laying on the couch, and then after you're laying on the couch, then what happens?
He came towards me, saying, picked up the candle holder, said he gonna bust us at my hand and kill.
I'm sorry, he picked up what?
A candle holder.
Candle holder, okay. Then what happened?
Said he gonna bust me upside my head and kill me.
Okay. So after he said that, then what happened?
He smacked me and I called the police.
When you say that he smacked you, how did he do that?
With his hand.
With his hand, was it an open or closed fist?
Open.
Where did he smack you?
On my face.
Where on your face?
On my cheek, my right.
On your right? Okay. Now, did he do anything after he slapped you?
No, I called the police, he gathered things and ran out the house.
Okay,
And then he bust my car back window.
okay. What did he bust? How did he bust your back window?
I don't know how he busted out, but he busted out.
Okay. After he slapped you, did he pick up anything else?
No.
No.
I called the police, we heard them on the phone. And they told me.
Excuse
we'll
me,
be on our way.
objection, hearsay.
Yeah. I'm sorry, let me go back. So you're saying, so it's your testimony that after he picked up after he slapped you, then what did he do?
He got his things.
When you say his things, like what does that mean?
His coat, his shoes. And ran out the window when he heard the police on the phone.
Mm-hmm. Okay. And then, were there any weapons?
Yeah.
There were?
Yeah.
Okay. What kind of weapons?
2 guns.
2 guns. Were those part of the things that he grabbed?
Yeah, he threw them in the backyard.
Okay, wait a minute. Let's go back a little bit. When You just mentioned the guns. First of all, like, what do the guns look like?
Two small guns,
Okay. When did he pick up the guns?
when he went in the back.
In the back of what?
In the back of the room, in our bedroom. He went in the bedroom, got the guns, and went outside, put them in the bag.
Okay, so he went into, let me just make sure that I understand. First of all, how long after he slapped you did you get the gun? Did he get the gun?
After he smacked me, he got his things and got the guns.
Okay.
Put them in the backyard, throw them in behind our garage.
Okay. Now, at any point, so when he, I just want to make sure that I get the sequence in it. So he slapped you, and then he goes into the bedroom, gets the guns, and then where do the guns go?
In the backyard behind our garage.
Okay. Okay. Now, at any point, did he do anything with the guns before he put them in the backyard?
No.
Okay. So he was just carrying them?
Yeah.
And he did, and you're saying, as your testimony, he didn't point them at you?
Yeah, he said, I'm gonna kill me and you. And then I called the police. I called the police. That's when he got the gun and threw them in the backyard, said they not gonna find them.
Okay. So at any point, did he point them at you?
Yeah, he pointed guns at me, showed me guns.
How many? Okay, so he pointed only one gun at you?
No, it was both, two of them.
Okay. Okay. So where were you when he pointed the guns at you?
I was sitting on the couch.
Sitting on the couch?
Yeah.
How far away was he from you?
He was in the dining room.
Which is maybe 5 feet?
Yeah.
Okay, 5 feet. So if I took 5 steps, it'd be about that far?
If I'm in the dining room, yeah.
Okay, okay. All right. So then now where was he pointing the guns at you?
In the dining room.
But where on your body?
Not on my, just pointed at me.
Just pointed at you?
Yeah.
Were you sitting or were you still laying on the couch at this point?
Yes, I was still sitting on the couch.
Were you sitting or were you laying?
I was sitting, stood up.
Okay. All right, so let's just make sure that I get the sequence of events here. He goes to get the guns, and then he immediately after he got the guns, he pointed them at you, and then he said something?
I'll object to you. Because initially, she said that,
Sustained, rephrase.
took the guns.
Okay, so let me see. All right, so where were you when you had the guns pointed at you?
Sitting on the couch.
Okay, then where did he go?
He got the gun, he went and got the guns, his coat and shoes. Came out the room and pointed at me, said he was about to kill both of them. So I said, the police was on the phone. He ran out the door and went to the backyard and put them behind the garage.
Okay. Okay. So then after he did that, what did you do?
I was still talking to the police on the phone, and then he bust out my window, in my car back window,
Okay.
and he ran up the street. And then he called me on the phone while I was talking to the police heard him and said, I'm coming down.
Objection, no personal knowledge.
Sustained. Okay. All right, nothing further.
Cross examine.
Good morning. You never sustained any injuries from this event, right?
Correct?
Had you been drinking also?
No.
You indicated that he had picked up a candle holder and was pointing it at you.
Yes.
Before the prosecutor introduced the idea that he pointed the gun at you, you indicated
Yes, he did
that it was a candle holder, right?
He did that first. He did the candle holder first.
Just yes or no?
Yes.
He's very able to rehabilitate your testimony.
Absolutely.
Okay, so when you were testifying just now, it's the prosecutor who had to coach testimony about a gun being pointed at you, correct? Because there was no gun pointed at
Objection,
you,
that's
right?
not legal conclusion, saying someone was coaxed.
But she knows coach. She
Rephrase.
understands coach. That's
Not a proper
not.
question, you're trying to sustain, rephrase.
All right, so it wasn't your testimony initially that a gun was pointed at you, you indicated that he went and got his things. Correct? Yes?
Yes,
And then the prosecutor said, what were his things, right?
yes,
And then you said, well, he got his coat, his shoes, and, you didn't mention, and then he got guns and took them to the backyard, correct?
yes.
Right, and so you never talked about it being pointed at you. All that time you were talking. Right?
Correct.
Until the prosecutor said, what did he do with the guns multiple times, correct, ma'am? Correct?
Correct.
Because he did not point the guns at you.
Yes, he did, ma'am.
Okay. Call the police on him like 13 times
Yes.
within
with domestic
2023.
violence. With domestic violence.
Nothing to do.
Can you redirect?
No, Your Honor.
So, Ms. Watkins, when you were initially telling us what happened, you told us how he smacked you in the face, how he pointed a candle holder at you, how he went to the back of the house to get his things, and it took some prompting or some asking, some questions to hear about his gunplay. Why didn't you tell us that from the beginning about him pointing the gun at you?
I just try not to say it.
Why? So, that's your husband. How long have you guys been married?
7 years.
And fair to say you love your husband, is that right?
Yes.
And you didn't initially tell us about the guns because you don't really want to hurt him, do you?
And I want to hurt people. I'm scared of it.
But you telling us about the guns and him pointing the guns at you, was that truthful testimony?
Yes.
Are you telling us the truth?
Yes.
Okay, now this car that he busted the window out of, you said that was your car?
Yes.
Is that car in your name?
My mom.
It's in your mom's name?
You got it for me.
Got it for you. Okay. Did you get that window fixed? How much did it cost you to get it fixed?
200.
Plus 200? Any questions based on my question?
No, Your Honor.
And you said that you didn't see him do it, but this happened right after he went outside?
What?
The busting of the window.
I heard it.
You heard it? Was it right after he went outside?
Yeah.
Okay. Any questions, Ms. Barnwell? We moving to add account of malicious destruction of property?
$200, yes.
I'd argue that, against that being added, I think community property was acquired during the course of the marriage. Even though her mom
She
gave
said
it
it was
to her.
hers, given to her by her mom. I'll let you guys sort that out across the street. We get some across the street. Thank you, ma'am. You may step down. Any other witnesses for the people?
No, Your Honor.
Witnesses for the defendant? People?
Your Honor, the people moved to bind over on all counts, and including the recently just added count of malicious destruction of personal property. Preserved for argument.
I'll respectfully object to this. I know my family farm counts, count 3 and 4. Based on the testimony that was presented initially, and based on coaching, prosecutor who elicited that testimony, this court still has to judge credibility, and that's a big factor. So,
I'm glad you brought up credibility. I found the witness was very credible, and her not necessarily want to mention the firearms to begin with was totally understandable. This is her husband of 7 years, and it's obvious that she still cares for him, probably a little more than he cares for her. Nonetheless, I found her testimony to be quite credible. I believe every word that she said about what happened. That being the case, the court is satisfied with the burden of probable cause as it relates to the charges contained in the complaint. The court finds those charges were committed in the city of Detroit. The court finds probable cause. Finally, putting over to the County Third Circuit Court Criminal Division proceeds his arraignment on the information dated timely in January 12, 2024, at 9:00 a.m. And so the record is clear. The court is binding over on all 5 counts, in addition to an added count 6, malicious destruction of personal property. Is this 600? Is it $200 or more?
$200, yes.
That'd be $200 or more, or 200 less. $200 for which one's?
I think it's.
I always know
200
that,
to 1,000.
I always know that I've seen it as the 200, so that's why.
But I know it's a
it would be
misdemeanor, Judge,
Yeah.
because she's the,
I'm sorry.
I believe it's a misdemeanor.
I believe it's a misdemeanor. 200, I believe, is a misdemeanor.
Yeah.
Okay, so whatever it is, can you get the statute for me?
Okay.
Thank you. All right, we continue.
And can I get a BSU referral, please?
We actually have one, and they recommend that the court reduce the bond to $50,000, $1,000 to 1%.
You said they recommended a reduction.
To 50,000, 10% of the total.
I respectfully ask for 5,000, 10%.
I'll adopt their recommendation of 50,000, 10% of the DPS.
He indicated that he would go live with his sister. You see his distraction, you see him friendly.
You want me to read the,
Yes, please.
it would be 750.3778
Thank you very much.
One.
AC1.
AC1.
A, apple.
A is an apple.
AC1, not A1C.
Let's try it again. A1C1.
A1C. Thank you.
That's the misdemeanor, right?
Indeed.
Also. Here's something.
Sure.
Unrelated.
Thank you.
Mr. Kenneth.
Yes.
Council, what's your last name? And what's your first name? Okay.
Still have a question. Still 15 minutes, an hour. Huh?
Okay.
Just know that you do not. I can do all the time. Tell my kids about
I tell my kids.
Mr. Dobbs.
Hi, good afternoon, Mr. Hunt.
Give me 1 second, I'm just wrapping up.
We got, yeah. You know, well, prosecution.
Your Honor, if this is Hunt, brought to my attention, this is a general trials matter, I don't know how we do that in this world.
Hold on a second. Melvin Hunt.
Yes, sir.
Prosecutor, my ATA.
You stepped out.
Calling case 2360506, people say Michigan versus Melvin Leon Hunt. Defendant is charged in count with assault with a dangerous weapon, count 2 domestic violence. Appearances for the record.
Good morning, Your Honor, Eric Decker, VA 5931 for the people.
Good morning, Your Honor, and your staff, Attorney Quinton Docs, number 79657. My client, Mr. Melvin Hunt. Hunt, please state your full name for the record. Melvin, Your Honor.
Is daytime set for preliminary examination? Are we ready to proceed?
Your Honor, I spoke with the officer in charge who was here and said that he served subpoenas on the witnesses. Unfortunately, they have not checked into the courthouse.
So order, court will dismiss the matter without prejudice.
Thank you.
Mr. Docs, I need a dismissal order.
Sorry?
Dismissal order.
That's right here.
Oh, okay.
Thank you. Okay, yes, we'll wait for it. Thank you. Happy New Year, Your Honor.
Thank you,
Your
sir.
staff.
Next, Mr. Washington.
Yep.
Mr. Ron Walker.
Yeah, check them out.
Calling case 2360542, Commission versus Sherrod Walker. Defendant is charged with count 1 home invasion, second degree, count 2 weapons, firearms, arson, count 3 weapons, firearms, possession by felon, count 4 aggravated assault, count 5 felon firearms, count 6 felon firearms, count 7 felon firearms, count 8 malicious destruction of personal property less than $200. Defendant has a habitual offender enforcement notice. Appearances for the record.
Good morning, Your Honor. Eric Decker, DA 5931 for the people.
Good morning, Your Honor. Earl Washington, Neighborhood Defender Service, 831383, on behalf of Mr. Sherrod Walker.
Tell me your name for the record, sir. It is a daytime set for preliminary examination. Are you ready to proceed?
Yes, Your Honor.
How many witnesses for the people?
Your Honor, right, I'm gonna say one, but I want to check on one thing, but yes, one right now.
Okay.
What's the name?
That would be Patricia Walker,
Spelling the first.
KATRESHIA.
That's all I need.
Thank you. Your Honor, the people would also move to, we have a certified register of action of prior convictions that we'd like to submit to the court. Criminal sexual conduct first degree from the July 20th of 1998 and criminal sexual conduct of the second degree from the same date from the Third Circuit.
Any objection?
Not for exam purposes only.
Admitted?
Okay, that's people's A. And the people called Patricia Walker.
Is that one or A?
A.
A?
Yeah.
Ms. Walker, please step forward. Raise your right hand. Will you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Thank you, man. Please have a seat in the witness box next to me. Keep your voice up nice and loud and speak to the microphone to your left. You may begin when you're ready. Good morning.
Good morning, ma'am. Just could you please restate your name for the record?
Patricia Walker.
Okay, I need you to speak into that microphone to your left, ma'am.
Patricia Walker.
It's easier for you.
Can you pick it up?
Okay.
Okay, so, just real quick, one more time, what is your state name for the record?
Patricia Walker.
Okay, so, now, in the courtroom today, is there anyone that you recognize?
Yes,
Okay, could you maybe point them out, tell me something that they're wearing?
a green outfit.
And, to be a little bit more specific,
It's in right here.
but, one more thing that they're wearing?
A mask.
Okay, now, let the record reflect that the witness has identified the defendants. So no, okay, so who is that person and who is he to you?
My ex-husband,
Okay, good, well, what's his name?
Sherrod Walker Senior.
Okay, so now you said he's your ex-husband, is that correct?
Yes, I'm in the process of filing the report.
Okay, so so tell me about your relationship with him.
We haven't been good.
Okay, let me be a little bit more specific. Do you remember the day of November 29th, 2023, so it'd be last year?
Yes, sir.
Okay, now do you have, I'm gonna give you an address also, 9335 Meringue Drive in the city of Detroit and County of Wayne?
Yes,
Okay, so is there, now what is that address?
my home where I live.
Okay, does anyone else live there?
My 5 children.
Okay, has at any point the person who identified as defendant, has any ever lived there?
Yes.
Okay, does he live there now?
No.
When did he, is there, how long ago did he move out?
August of 28th.
So why did he move out?
I don't know.
Okay, but you could just say that.
I came home from work and he was packing stuff and said he was leaving.
Okay, so after that, was it still his residence?
Yeah.
Okay. So it's your testimony that he didn't live there after that day?
Right. He's never stayed there after that day.
Okay. So has he ever contacted you after that?
Yes.
Okay. How did he contact you?
Ringing the doorbell in the middle of the night, to ring in the middle of the night, calling, text messages.
Okay. How many calls would you say?
Hundreds.
Hundreds?
Yeah.
So how many times has he rung the doorbell in the middle of the night?
2-3 times a week.
What time is the middle of the night?
2, 3, 4 in the morning.
Okay, and has this happened on more than one occasion?
Yes, sir.
How many would you say?
Since August, maybe 20, 30 times.
Okay. Did you want these communications?
No, I didn't.
Did you ever tell him that you didn't want to have these communications?
I told him several times that he left,
How did you tell him?
that he left each time he asked.
What I mean is, what did you use?
I talked to him on the doorbell, I talked to him on my phone when he would call.
So then after you told him that you didn't want to speak with him, then did he ever contact you after that?
Several more times.
All right. So I apologize. Let's now go back to the date I was talking about before. November 29th of 2023. Did you see him on that day?
He was in my driveway.
Okay, so he was in your driveway, and then what happened?
I probably need to go to work.
Let me come back a little bit. So you saw him in the driveway, and what time was that?
7 in the morning.
7 in the morning? Okay. What was he doing?
Standing behind my car.
Okay. So were you expecting to see him that day?
No, I wasn't.
Okay. So when you saw him, then what happened?
I still left to go to work.
Okay. So then, you left to go to work, and where was he?
Still standing in my driveway.
Okay. Okay, so then, did you see him at all after that?
Yes, I pulled out my driveway and I'm not sure what he said, but once I looked back, he was turning around, pushing the window out the door to go in the house.
Now, how could you see that?
Because I hadn't pulled completely out of my driveway.
Okay, so when you say he's pushing, like, what was going on?
The window, the pieces that holds the bottom of the window on the security door, some of them are missing.
Okay,
So if he pushed the door, the window in and unlocked the screen door and went in.
Okay. Now, what did you do when you saw him do that?
I made a U-turn in the middle of the street and I came in the house and I asked my brother-in-law, did he go upstairs or downstairs?
Okay, so you can, so now, okay, I just want to make sure. So you do a U-turn, you go back, and where was he?
In my bedroom.
Okay, I apologize. Was he inside or outside of the house?
He was inside the house.
Okay, so did you see him go inside the house?
Yes, I did.
Okay, so then that's why you did the U-turn. Okay, so now, so you go back into your house, and then where did you go when you got into the house?
I walked through the kitchen, the dining room, into the living room and asked which way did he go.
Okay.
And I had the police on the phone at the same time.
Okay. So after you asked that question, then what did you do?
Turned around and went back out.
You went back outside the house?
Yes.
Okay, so then what did you do after you went back out of the house?
I got in my car because I knew he went in for my purse and my gun.
Excuse me?
I got back in my car because I was scared, because I already knew what he was going in there to get, my purse and my gun.
Okay, so then what did you do?
I pulled off.
Pulled off. Okay. Okay, so, but you said that the next time you saw him was in your bedroom?
No, I didn't see him in my bedroom. When I pulled out the driveway and I looked back, he was going in the house. The next time I saw him after that, he was coming out the house.
Okay, so, okay, so then after you pulled off again, then what happened?
He came out the house and I had the police on the phone. I was telling them which direction he was going in.
Okay, so then after that, what did you do?
I went back to the house to wait on the police.
Okay, so then after that, what happened?
The police came and took the police report.
Okay, but what, so when, all right, so what did you do after the police arrived?
I just told him what happened.
Okay.
That was it.
Okay. So you told them what happened, and then now, you talked earlier about the person and the gun. How did you know that that was something that was gonna be, that was?
Because I know him.
All right, well, you said you were married. How long were you married?
10 years, February 6th.
Okay. So how do you know so do you know if he did grab your gun in purse?
I know, it's not there.
How did you know that?
Because the stuff that he had in his bag, he dropped on my bed. So he put my purse in the bag he had. And I know he had it because he tried to use my card in the store down the street from my house.
Okay, let's go back a little. So how did you know that that was his bag? So
He had the bag when he was standing in the driveway.
Excuse me?
He had the bag with him when he was standing in the driveway. He
Okay.
already had a bag with his own stuff in it.
Okay, and what was he holding it?
Yes.
Okay, so then where was the bag? So then when you saw him go inside, did he have the bag?
Yes.
Okay. So then when was the next time you saw the bag?
When he was leaving back out the house.
Okay. So. So then after that, after you saw him, so you saw him leave the house?
I'm still there.
You're still there? Okay, and then what was he carrying when he walked out of the house again?
The bag that he brought in the house with him.
Okay, and then where did he go?
One block down and he cut through the past houses and I didn't see him after that.
Okay, so when the police came, what did you do?
Told him what happened.
Okay, and did you go back into the house ever?
Yes.
Okay, and let's just go over this again. Then did you see anything unusual inside the house?
No.
No, nothing was missing?
Nothing but my purse.
Nothing but your purse?
Right.
Okay, so where was your purse? Where did you leave your purse before?
In the nightstand.
Okay,
Where I've always leave it.
okay. Okay, so then what was there, how about the gun?
It was in my purse.
No, that was in your purse?
Yes.
So the gun was gone along with the purse, okay,
Exactly.
okay. Okay, now, did you leave the house, after the police came, were you able to leave the house again? Were you able to go to work?
No, I didn't go to work
Why not?
because he had my gun and he had been telling me for the last 2 weeks that he's gonna kill me on my birthday.
Okay. When you say the last 2 weeks, how was he doing that?
Text messages.
It was on text messages?
Yes.
Okay. Has he ever done anything else?
Never.
I mean, I'm talking about like anything to your, anything to your property?
He scratched my car up. He flattened my tire. He took the license plate off my car. He went in my car and disconnected the battery.
Judge, I'm gonna object to all this testimony about prior events, prior activities before, November 20.
Let's get a timeline. Is this talking about the same incident?
I don't think we're talking about the same incident.
I'll sustain that.
Okay. All right. Okay, now we were talking, before about, okay, so has he ever done anything to property of yours?
On that day?
No, has he actually specifically, now, when did you say that he moved out?
August the
You know what,
28th.
I have to retract that ruling on that objection, because one of the charges here is aggravated assault. So if he's trying to establish a pattern of conduct, then it will certainly is relevant. So I'm reversing myself.
Okay, so, now, in the period of time after you said that he moved out, and was there ever any time that he did anything to your property after that?
Yes.
Okay, so what would that be?
Disconnecting the battery in my car.
Let's just go back. So you're saying that he did something to your car?
Yes.
Okay, what did he do to your car?
The first thing he did was disconnected the battery.
Okay, and was that
It's
then?
not under my hood, it's in my car, in the floor.
Okay, now, did he ever do anything else to your car?
Scratched my car up.
Now, was that?
I know he did those things.
Because he did it while he was in my driveway.
You saw him do it?
It's on my Ring camera whenever he's in my driveway.
My question is, did you see him do it?
No.
But you saw him in your driveway right around the time these things happened to your vehicle?
Yes.
Okay, and was that on a Ring video?
Yes.
Okay. Okay. Now were the incidents that you're describing, of disconnecting the car, disconnecting, scratching up, and then was there another?
My tire.
The tires, what happened to the tires?
Flattened the tire.
Now, was those all one incident or?
No, it all happened on different days.
Okay. Nothing further, Your Honor.
Cross examine.
Good afternoon, is it Katrina Walker?
Patricia.
I'm sorry, Patricia Walker. All right, good afternoon, Ms. Walker. Ms. Walker, you were still married to your husband Sherrod on November 29th. Would that be a good thing?
Yes.
Okay. On November 29th, Mr. Walker still had keys to the house, is that correct? You're saying he didn't have keys?
He does not have the keys, I have the keys.
Okay, is Mr. Walker's name on the property?
Nothing.
So you're saying his name is not on the,
I
deed
own the
or
house.
papers?
It's in my name.
Okay. Wasn't Mr. Walker, paying on the mortgage in that house?
No, he was not.
Now, you indicated that you have a Ring, video at your door, is that correct?
Yes, sir.
All right, and, were any of the events that occurred on November 29th of 2023 captured on the Ring video?
Him standing in my driveway, and him going in my house, and him coming back out of my house.
So what you're saying is you had that on video?
I sent it to the detective.
Okay. Did you send it to the detective, well, let me ask this question. How long after all this happened did you send the, ring video to the detective?
I probably done maybe 2-3 days later.
Okay. Now, you indicated that, there were prior incidents, that you accused Mr. Walker of doing. Do you call that testimony?
Yeah.
Okay. Now, did you notify the police after any of those events?
I have reports for every last event.
So what you're saying is you have police reports?
Yes, I do.
And to your knowledge, were any charges filed from those reports before November 29th?
I'm not sure.
Okay. But to your knowledge, you don't. Okay.
No.
Now, you say on evening of November 29th, you say you were in your house when he knocked on the door?
That was 7 o'clock in the morning, a.m.
Okay, you were in your house?
Yeah.
Okay. And you say you have video from the ring camera at, from the events that happened at 7 o'clock?
Yeah.
Now, you said that you left your house and went to your car.
My car is in the driveway at the door.
Okay, but you went inside your car?
Yes.
Okay. And how long were you in your car?
Long enough to start it up to pull off.
Did you pull off?
I pulled to the end of the driveway.
Okay. Was any damage done to your car?
Yeah, it took the license plate off my car that morning.
Did you ever recover the license plate?
No, I didn't.
Did you tell the police that one of the windows was broken?
Because the window out of the door to go in the house.
Okay. Did you say that the window was broken?
Yes, the window is not broken. You just, I mean, the way it's up there, the little hooks that hold the security window in. That part is broken.
Okay. So, and again, let me back up. When I say broken, I mean,
Glass.
was the glass broken or shattered or anything like that?
No.
Okay. Were any repairs done to the window?
I just brought the little pieces to hold the window back up.
Do you have a receipt for any of those?
You know, I have the receipt for my tire.
Okay. How much was the damage to the tire?
$40 is what I paid to have that.
And you have the receipt?
Yes, sir.
Did you give that to the police?
No, I can't.
Now, the damage, you talked about a flattened tire. Is that your testimony?
Yes.
Okay. And you had that repaired?
Yes.
Did you have a receipt for that?
Yes, I have the receipt for that. I don't have it with me, but I do have the receipt.
You had a receipt for that? And you said a scratch was done to your car?
Yes, he scratched my car on 2 different sides.
Was that repaired or anything done for that?
It hasn't been repaired.
But you still have the scratch on your car, is that correct?
Mhm. Yes.
Is that a yes?
Yes.
Oh. Did you take a picture of that?
Yes, I have pictures of that.
And did you give that to the police?
Yes.
Now, you say that he took your gun, is that your testimony?
Yes, sir.
Did you see him do that?
It was in my purse. He took the purse.
No, that's not the question. Did you
No, I
see
did
him?
not see him do
Okay,
that.
you didn't actually see him take the gun, is that
No.
correct? Okay. And what else did you claim that he took?
My purse?
Did you ever get your purse back?
No.
Did you see him take the purse?
No.
Now, he left the house, correct?
Yes.
And after he left the house, you went inside the house, is that correct?
Yes.
And how long after he left did you go inside the house?
Or about 2 hours later.
Okay, so you're out of your house for 2 hours?
I was still parked on the street.
Okay. Was that in your driveway?
Yes.
And forgive me for asking that, maybe I didn't get that clear. The 2 hours, was that 2 hours, that passed before you called the police, or 2 hours?
No, I was on the phone with the police when he was in the house.
Are you on your cell phone?
Yes.
So the police arrived 2 hours late?
No, the police arrived 20 minutes later.
Okay. One moment. All right, Ms. Walker, were you upset with your husband because of another woman?
No.
Objection. Relevant. Well, it's always relevant as a credibility quiet person. You say you weren't upset with Mr. Walker because of another woman.
No.
Did another woman send you a video that you disapproved of?
Yeah, she did.
She did? Okay. When did you get that video?
The 20th or something like that.
Okay. So this was about 9 days before all this happened?
Yes.
Okay, then. And you're upset with your husband because of that video, is that
No.
correct?
No.
Isn't that why you're saying all this?
No.
I have a further question.
Can you redirect? Yeah. Hey, ma'am, you said the defendant is your ex-husband?
Yes.
When did you get divorced?
I'm not divorced. I'm in the process of divorce.
So he's not your ex-husband legally yet, is that right?
Correct.
Okay. You said that he left the house. You didn't know why he was leaving?
He told me he had an apartment.
All right. I take it since you were married at the time, and you're actually still married, and you both lived in that house together at that time, right?
Yeah.
Did he have keys to the house?
I have the keys to the house.
Did he have a key to the house?
Well, that time, no,
Why didn't he have a key if he's your husband and you lived there?
because he gave the key back.
When did he give the key back? When he was leaving?
Prior to that day.
Prior to that day, he gave you the key back?
Yes.
Did you ask him why he was giving the key back to you?
I didn't care.
Okay. Did you change the locks at any time?
No.
All right. You said that throughout this period of time, he kept showing up at the house at odd periods of time, day and night, is that right?
Yes.
What was he showing up there? Was he trying to get in?
Sometimes.
And you told him he couldn't come back in because he left, is that right?
Exactly.
But legally, he still had rights to the house, didn't he? Because you were married, right?
Yes.
And you said on this day that he broke into the house, so to speak, that he pushed the window in to get in, is that right? That's as if he were leaving, is that correct?
Yes.
And you said you knew he was going in there to get what?
My purse and my gun.
Why did you think he was going to get your purse?
So that I can protect myself.
What made you feel that way?
Because in the upcoming days leading up to that day, he kept telling me he was gonna kill us both.
You said you made a police report when you did that?
Yes.
And did you say he did something to your car? He did a number of things to your car?
Yes, sir.
And this car is in your name?
Yes.
And you say you didn't get your purse back. Did you ever get the gun back?
No.
Did anybody else enter your house in
No.
that period of time? Any questions based on my question?
No, Your Honor.
Well, Ms. Walker, you testified about a number of incidents involving damage to your property. You testified to threats made by your ex-husband, yet you never did have the locks changed?
He didn't have a key to get in.
Well, ma'am, the question is, you never had your locks changed?
No.
Okay. And ma'am, the video that was taken, that was a sex video between, your husband and another woman, isn't that correct?
Yes.
And isn't that why you're upset with him?
No.
Isn't that why you're stating all this?
No. Objection asked and answered.
I have a question.
Is there any reason why you didn't try to get a personal protection order?
I did. The lady name is Tracy, 5th precinct. I had to make an appointment.
First, personal protection orders goes through Wayne County, has to go through Wayne County Circuit Court.
They kept sending me to the 5th precinct.
Wayne County Circuit Court sent you to the 5th precinct?
The detective sent me to the precinct and the cops that kept coming out from my house. Kept sending me to the 5th precinct.
Sounds like enough information, but okay. Any other questions?
No, Your Honor.
I have no question.
Thank you, you may step down. Any other witnesses on behalf of the people?
No, Your Honor.
Any witnesses on behalf of the defendant?
We have no witnesses.
People?
People motion for bind over on counts 1, 2, 3, 4, 5, 6, 7, 8. As to the home invasion charge, there was some kind of question about whether or not he actually was the person he actually had a right to be in the home at that point. Remember that the conduct that she was talking about, and it's also in the complaint, started on August 28th, 2023, which is when apparently he handed over the keys, according to the testimony, handed over the keys and essentially told the complaining witness that he was going to no longer be in the residence. If I hand over the keys.
Rights to property though?
Pardon?
Does that extinguish his rights to the property though?
I think it establishes the intent to not be at the property, and especially.
No, but does he still have a legal right to that property?
Legal right, well, I mean, is it an apartment that there?
I don't know.
Okay. All right. Well, I mean, yes, it wouldn't completely extinguish the legal rights to the property.
Right. So you can't break into your own house.
But other than that, yes, that's the people motion for binding over on the Third Circuit.
Washington.
Judge, you brought the point that I was going to argue against count 1, sir. That has not been established. I'll place an objection to our argument.
Speak a little louder so the court reporter can hear you.
Oh, I'm sorry. I object without argument as to the other counts.
All right, the court, after hearing the testimony of Ms. Walker, is not satisfied with the burden of probable cause as it relates to count 1, home invasion, 2nd degree, and that the parties were married, and this appeared to be the marital home at the time, and the defendant, although may have relinquished some rights to it by turning over the keys, he still had a legal right to that property. So the court finds insufficient evidence to bind over on count 1, home invasion, 2nd degree. Counts 2, 3, 4, 5, 6, 7, and 8. The court finds that people have met their burden of probable cause as it relates to those charges, and that allegedly the defendant went into the location, took the complainant's purse, that also had her gun in it. That he was, did we get a stipulation as to the defendant's criminal record?
Yes, Your Honor.
We did.
Excuse me, Judge, if I might interrupt. As to count 5, I think the predicate for the
felony firearm
is
the home invasion, yes, that would be dismissed as well.
Okay, thank you.
All right. Counts 2, 3, 4, 6, 7, and 8 will be bound over as charged. Court finding those charges were committed in the city of Detroit. Court finding probable cause to believe this to be committed. is arraigned on the information date and time will be January 12, 2023 at 9 o'clock, 2024, at 9 o'clock a.m. And bond will be continued.
Thank you. Your Honor, in this case, also, I've just been told by my victim advocate that that there apparently was also a violation of the contact order in this case.
Okay, that's not very smart. How so?
The allegations are that there was some calls and video chats, or requests to video chat from the jail. If you would like me to continue.
So are you trying to get your privileges taken away altogether? No, sir. Do you understand that you are not to have any contact whatsoever with the plaintiff witness? All right, so before I waste any more time on this, sir, let me tell you, I don't like being lied to. And if I find that you're lying to me, it's not gonna go very well for you. So if you did attempt to make some contact with me, you probably need to come clean on that now, because if you lie to me, it's not gonna go over very well. You understand? Did you try to make contact with her? I tried blocking her on the tab. Why would you try to block her? Was she trying to contact you?
They came through and she's the only person that knew I was locked up.
She tried to contact you?
She's the only one that knew I'm locked up.
I didn't ask.
Yeah, she did, so I tried to block her on the tab.
And it accidentally called her, is that what you
She didn't, can't call her.
Understand this, sir. I don't know what your history is. She doesn't want anything to do with me anymore. And when you try to contact her, she's going to tell. Okay. You understand that? Yeah. She's going to tell. For whatever reason, maybe it was the sex video she saw, she's going to get you. She's going to tell. And don't give her the ammunition to put into the gun. Okay? You understand that?
Yes.
This relationship is over with.
It's done.
All right?
Done.
I need you to realize that though.
Done.
You keep it up, you're gonna get all your privileges taken away. You won't be able to contact anybody.
That's it.
I'll be continuing.
Judge, can, the court order ESU on this?
Okay.
That's it, that ain't gonna get you.
Okay, we are down to 1:30. Make it 1:40.
And again, I apologize.
Take a seat for a minute, Mr. Watson.
Good.
It's underway, sir.
Yes. Okay. Okay.
Yeah. Have COVID. We will get tested. Running a fever.
Hey, we're on lunch till 1:40.
Okay.
So I'm trying to get. You're excellent. It's been going. Mhm. And. When it was your COVID, no way.
Yeah, y'all want this order now too? Hey, those over there. So,
You need time, yeah, okay. Thank you.
Are you in the room? Are you in the room? Let me know, you know, if it's not during the. All right. You want me to talk to the nurse? Ring your bell. Don't come in and wants to place me when I get the whole test. Oh, you know, like go to the desk and tell them that you mentioned that you need some ice and you want to get the COVID test. The nurse said, you know. See there. We can split up and tell both and give you some reason. See, close it. Get it done. Because if you do, you don't want to give everyone pages. You know? Okay, take care of yourself. Let me talk to you in something. All right. Gonna have lunch, Judge? Gonna have lunch?
Yeah, I'm gonna step out.
this prosecutor, he just cuts his sentences off. Straight nuts.
Yeah, he said, they all have a little bit of a different style.
Well, he's not familiar with the cases, you know, on which I can understand.
Right.
That's why, this case. I'm pulling it up. All right, I'll be back.
Okay, enjoy.
Yeah, I'm just gonna go to the office. I had a banana. Hey, Connie's in Ann Arbor Hospital. She's been diarrhea, throwing up, running a fever. So he had to take me all the way up. I said, why didn't you go to Beaumont? He said, I'd never go to Oakland. I said, since they've been Beaumont, it's a good hospital. So my mom's been there, I've been there. I would highly recommend it. She said, oh, I didn't know that. I said, yeah, you know, she's still in the waiting room, waiting. You see, I told her, I said, did you get a COVID test? And she said, no. I said, you need to tell them with your symptoms, you were in the nursing home and you got the symptoms, you went a COVID test, and you don't want you drinking water, get some ice. You know, you've got to be hydrated. So, you know, because she called me this morning, thinking, you know, I could take her, but I'm at work. I said, I'd love to, but I'm not at work. So I feel bad, you know, because I had times when they go into Beaumont. Yeah. Because I like that hospital. I go there whenever I need to go, you know, and they've always been good and treated my mom. What? Yeah, it used to be open, the Beaumont took over and they got all the help and everything. It's really good. In Botsford, they turn into Beaumont. They're good too. But I used to go to Botsford because I wouldn't go to Oakwood. Since it's been Beaumont, I go there if I need to go. But she didn't know, and she sounds terrible. Yeah, you know, Leo's there and he's sleeping. I said, well, wake his ass up and tell him to go up there and get you some ice and have you take the COVID test because you went to the nursing home. You could have picked the bug up, you might as well get tested. Yeah. And not get anybody infected or make it get worse. You know? Because I tell you, that's real contagious, those nursing homes. Yeah. So. Her symptoms, she's got a fever, she's vomiting, she's throwing up, you know. I put that her. Oh, today is crazy. This prosecutor, Shelley's not here today, she's been sick. But yeah, she's been doing virtual, but you can tell she's sick. This guy, I mean, he doesn't know the case, he just cuts off the sentences, talks so fast, does not finish. I said, constantly slow down just a little. He said, I know I'm covering 2 courtrooms. I know. I said, but you have a nice record. You know, you're gonna have a bunch of dashes in there. Yeah. So he slowed down a little bit. So what's going on over there? Well, it's been crazy here. Everything's been going. These husbands and wives. I mean, these guys are nuts. Yeah. Yeah, in this last one we had, her husband, the girl who was filmed, and he takes a video of it and sends it to her. To the wife. What kind of crap is that? I mean, you know. It's just something else, you know. You only had 1 dismissal today, and the rest all went. They were all crazy. And there was one girl living with this other girl, and she works at home, and she was at their friend's house and had her car for a week. And she went, yeah, well, kept it going for a week and you know, didn't get permission. Was hanging out at this house, but the girl went over there with a gun, hit her in the head with a gun, shooting in the air. So she got bombed over, but she shouldn't have let her, she should have just reported it to the cops, kicked her ass out, you know? So it was crazy cases, just crazy. Yeah. I know, it's been like that. You know, just, I don't know, just crazy. Such a crazy shit. All these TVs, you know, all of it. I feel good, just my nose running from this carpet being around here. Other than that, I feel pretty good. I gotta get home, I gotta finish this transfer, I just didn't do shit last night, I'm tired. I gotta get to the store. I don't have enough for the weekend. So I gotta see what I gotta do. All right, so I thought I'd let you know about Connie. I'll give you a holler later. Are you at lunch? You at lunch now? Yeah, I'm sitting here, we're starting at 1:40. Yeah, all right. I will, I'm gonna see how far I get on these trains. I gotta work tonight. And, I'll see, you call me when he gets done. And I'll see what time it is, because I could go ahead and at least finish laying it and then come out Sunday and grow it, you know? I wanted to sit, at least that part's it. Just depends how fast it heals. If you keep the heat up, you know, then it dries real fast. Yeah. But I'll play by ear and see. All right, when he's just about done, give me an idea about when he's gonna be done. All right, kid, I'll talk to you tomorrow. All right, all right. Yeah, I will. All right. Bye.
Oh, yeah, yeah. Seconds. Then I will be right back.
I forgot to tell you that Jeanette texted me. Her mother-in-law passed away, and that's a big, they had her yard all full with plants and stuff. And her dad's going in hospice. Dementia. Yeah. No, so I don't know how long he's.
Terrible. Listen, good. Did I ask you, did you want to go to the funeral on Sunday?
No.
Okay.
I don't like funerals. I go, if I don't have to go, I don't want to go. No, and that's gonna be out in Monroe, not Monroe, but Macomb.
Yeah, I'm gonna.
Yeah.
So I didn't know if you wanted to go up there to.
No, I think it's too depressing. Too much depressing. I want to remember him alive.
Yeah.
Yeah.
I didn't know if you remember or not, if we were gonna do your plan, so.
Yeah. Yeah, I remember. Her mother-in-law was so cool. She was so nice. That's sad. Yeah, she was really a nice person.
Where's she gonna be laid out?
I don't know. She didn't tell me, but it doesn't sound like the dad's doing very good.
Yeah.
So,
That's.
yeah, that is.
Sorry to hear that.
Yeah, I know. I'm like him too.
Yeah, it's not, you don't remember me, but,
He
you know,
probably remember you.
you know, when you get dementia.
Yeah, and he's at the point, I don't think he'd remember me.
Dr. Rita, nice guy.
Yeah, no. Yeah. So if he passes, I'm gonna go there. You wanna go with me?
And the deer were home, that's it.
No, the funeral, that's correct.
Yeah. I know.
Yeah, me too, at least to show my respect, because I did like him very much. He was kind of personal, only friends and real close communities.
Yeah.
You know? It's about it. So I've got to tell you that, I'll let you know. So call me when, give me an idea when you think you'll be about finished so I can head out.
Okay.
All right, talk to you later. All right, bye. Hey, I used to work. Yeah, Bill that did my house, he's going in hospice. Yeah, Jeanette texted me. Hospice, because it's all types of stuff really bad, it's not still right now. Yeah, I will, because I was close to him. So, yeah, that's sad. And her mother-in-law asked me, which I was close to her husband's mother, because she used to Joey, kid, JJ, and she used to give me tons of stuff. Or she had her gorgeous. Jesus, so both of them. Again, I just need to look at this. She's working for Jefferson, so. She was in love. I just say hi, I'll be working. She was a talk. I didn't talk to her that much. I was getting on the elevator, you know, when I left it. I said, I don't. Yeah, me too. No. No, and you turn around and talk shit about it. You know? That's what I try not to see in her. No. Why would you want to do that? No. No, 140. Today was Shelley's been sick, so that this hunter, you know, maybe that Peter, that you know who he is. And kind of chubby, talks things, he cuts his senses. Do that. This. Oh my God, everybody says, yeah. Heck yeah, so the judge came. And yeah. Yeah, because everyone's sick. And Connie's in the hospital in Ann Arbor. Connie, my neighbor, she called me this morning. I know, and then she's vomiting, throwing up, running a fever. She went all the way up to Ann Arbor. She said, I don't want to go back to the home. Oh my. I did my mom, I was there, you know, excellent. Yeah, I didn't want to be out. Couldn't quite help anything too, which is good. That's what your body tells you, just follow it. Yeah. Yeah, you probably need to. Your body is telling you something. All this shit going on, you know. So I don't know how long time she's still waiting. I talked to her when we broke, I said, tell me, I said, we're gonna dehydrate, get some ice, tell somebody, get some ice, get your COVID test.
Yeah, where's her husband?
He fell asleep, he took her, but he fell asleep. I said, is that so? Somebody said, well, he's got dementia, but he can drive as long as it's in the car. He's not too bad. Huh?
How you gonna get back? Ain't nobody gonna get
Keep her away. That's the problem. And our, that worries me. That's why she called me when we take her when I work.
Yeah.
You know? So. I hate seeing him drive because he falls asleep. You know? He's dangerous. He shouldn't be driving. She could go to Beaumont. Yeah. Yeah, and I'll take her up there. I'll work on it. Yeah, I'm gonna talk to them, see if they want to keep it safe. Checking that Beaumont, that's what I can take this in, drive it home alone. Yeah. But you need to get tested for COVID, they said that if you've got symptoms, you in a nursing home and that place is contagious. All the nursing homes, they're the worst.
Yeah. And you know where you say, rise.
Oh, yeah. That's
right. That's why every time you get an itch, or any kind of pain, you go.
Oh, yeah. Yeah, I test all the time. I'm not taking it to. No, if you're not running a fever, you know, if you get feeling bad, you know, my nose is running the best because I'm here. Allergies.
Okay, I just have, I just had chips out, see chips last night. I got lost one time.
Yeah, but do they have sugar in it?
Yeah, they got sugar in them.
I didn't. It's just salt.
No, I don't, they got a lot of glucose. Sugar don't necessarily mean anything sweet. Just extra glucose.
That's sugar.
I got that OSD, yeah. Even though it was,
yeah, they still have all the additives. Yeah, we got a big bag of chips in the drum. Just eating it, opening up and eating it, but I'm mistaken.
I know I had to rest up that shit.
Yeah, that's what made you tired, you know?
That's what, you know, because you know, my blood sugar is.
Yeah, yeah.
This medicine, you know, this.
Right, right. Yeah, get that fluid, and I've been drinking fluids too. And then water, and that helps me a lot. Yeah. That's good. Yeah, I'm not drinking a lot of tea. I ran out of tea. I gotta get to the store. I gotta get tea. I gotta get cream again. I gotta get some salads. Yeah, yeah. And it's always costing me money, you know? Yeah, I got just lettuce. I don't have anything else for it, you know, but I just want to wait till tomorrow. I gotta get this transfer done. I did do shit yesterday. We finished it on the last witness on cross. Coming home watching Netflix. You know, feed the dogs, took them out, moved around a little bit. I gotta clean my house, got my wash color. But I gotta meet Susie coming out. I doubt this weekend. I got work to do. I gotta get my house done. I gotta get these transfers done. And we have nothing ordered for this. Nothing ordered, you know. that I had to order. Monday was all probable cause. Tuesday. We did. Tuesday all probable cause, which was the homicide. John, no, she's never listened. He's always done, always, never looks fast. He gets that stuff going, he doesn't let him argue a lot. And I love very rare. It's not real common, right? So, but
I care. Well, I care a little bit.
He's
like this week, it's real one, so I can't come. Next week, we're gonna have the Jewish week. She's coming back next week. Next week. Next week, I'm sorry, the week after. No, I'm missing all next, not this Tuesday, but next Tuesday, he's got 3 good cases. No, just there next week. Yeah, the 16th. No, I'm gonna, no. Yeah.
We have not heard from this complaining witness like
That's
ever.
the next, that's the 16th, right?
11.
Yep. Here, yeah. I did already say this. Yeah. Just, yeah. You what? What do you mean? Yeah, but it's union. She told me they're union. Yeah. It's a big union they gave. Probably. Oh, and that's gonna. She's working at Jefferson this week. I don't know. No, I don't know.
What time did you say come back?
1:40.
Oh, okay.
Yeah. Holiday time, so they're color.
need to share those teachers.
It's gotta be following, you know? He should be. You know, he should be. He's good, he's a good judge, you know, he should be. I watch it. Because he told me this on this one. Last week's. Two girls. Saying stuff. Shut up, shut your mouth. Talk. Oh, yeah, yeah, oh, yeah. Because the witness was saying. Contact. Quiet. He doesn't. I like action. All right, Mike, I'll let you go again. All right, I'll let you know all kinds of stuff. I don't. Okay, so I'm gonna have to stay home. I'm gonna have to tell you. She's gonna have to wait for a destination. That's your problem. They're 2 weeks off. 2 weeks. You know? Yes, people. Kind of like. No.
Very professional, very.
Yeah, but she's pretty good about. Judges. All right, I did. All right, yeah.
The defendant's lawyers out there. The defendant's lawyers out there.
Marshall,
Huh?
was that Marshall out there? The
Yes,
last case,
yes.
was it a female or male?
Ma'am,
You know his first name?
I don't.
You.
H-U-G-H?
Yep. 48269.
Yeah.
Get your butt here. I see you walk down too. Like, I was you going the wrong way. It's talking about this paperwork too. Like, y'all got one.
Uh-huh, well, that's the only one they missed.
Yeah.
Okay.
Get your butt here.
How
Go on.
was that? I know that's right.
Top shelf all out.
Let me get it together here.
Oh, you already signed it. Look at you go. That's somewhere you need to be?
I'm gonna put my earpiece in one second.
Actually, John. We also certification.
Oh, what's that? Oh.
Law enforcement officers, you should, as a prosecutor, report that.
Okay.
Judges, law enforcement officers, prosecutors.
Wait, you get that paperwork down there for me.
Oh, yeah, no problem. Yeah.
So efficient. You're so efficient. Just wait on this last one right here. They're just calling up your phone.
Yeah.
States.
That's cool. There you go.
Are you?
No. You drove, right?
Sure.
I was gonna walk over, but I still had my oatmeal this morning. Ain't nothing in it but cinnamon.
That's
And
all.
orange. God, I get a salad there. Yeah.
Huh?
You know what? I mean.
I was spinning plates.
I should have called.
I can't believe it.
It's all 10 minutes. I got back, I'm like, I know something.
Yeah, I was, and I was upstairs and, Judge Jarrett or a little.
Really, they go in there too?
No, they weren't going, but there were pre-trials, and so I still had matters I had to do. I still had stuff to do. Because Shelley said.
I forgot he wasn't here.
Yeah.
I'm sorry, Brother Walker. See, like.
Oh, it's like 10 minutes.
Yeah, I know.
Shelley said.
Yeah, she was sick.
I showed some self-control yesterday. I was like, good job, man.
Oh, what was going on?
I know what you're talking about, because some things, I was saying that earlier, some things you just ought to keep to yourself. I mean, we have fun, but.
Don't too much too far.
Yeah. Oh, you talking about upstairs?
Yeah.
Oh, you did set the trouble, stay
Yeah.
place. I said,
Oh,
I didn't want to do what you was talking about, but you give me some age.
Plates.
You don't think, like on the solar show, you got.
In school, they was called that book.
Yeah, just left it alone.
Hmm?
I just left it alone. We burned the bridge.
You gotta go out sometimes, don't
Yeah. And take it to the range and everything. Those kids driving that. Learn your way now.
I never. You might, that's what everybody's age. Little sister.
Lady downstairs was totally different.
Ah.
The lady
Oh,
downstairs,
done? Yeah, she lost a lot of weight. Done.
Oh, yeah, she sure did. From when I first, the other day I saw her the first time, like, who is, I thought it was a new.
So it's totally different.
Yeah.
That face was slim down everything.
Long hair and stuff. Something else back in the day, probably.
Yeah. She back to it.
Because we put a tether on you.
She had a surgery like maybe 9 months ago. 10 months ago.
Oh, did she do this?
Yeah.
That kind of certain things you can't.
We've done so much. I don't know if she had it. Maybe she had a sleeve or something small.
If I was like that, every time I eat, there had to be something good. Tickle my taste bud.
My wife still, she had it.
But
that's
good. I wasn't there for myself.
How
She let me down slowly.
Huh?
She let me down slowly.
Let me ask you
It's
this. I know your amount's gotta be small, right? You eventually be eating more times a day.
You're supposed to eat actually. Tell people that was it. Snack like fruit and stuff.
Supposed to give my.
She'll start eating something, take a couple bites of it.
Yeah. She can take vitamins and all that stuff.
Yeah. She gotta take that rush hour. They said she gotta take a rush hour.
Yeah.
But you should be taking vitamins anyway. You know what I'm saying?
Yeah, but when they tell you, you got to. They told Ann the same thing, some stuff she got to do. So you got a date? You got decided on it?
Yeah, it's on the end of the month.
Oh, really?
Well, from the 22nd all the way to February.
Oh, you gonna put her out there first, huh?
Just
Just the water.
You got the same doctor, he's like, she gonna be your baby.
Say you want to take water yet.
No.
Let me get y'all that last
You
one.
said that, I thought you were talking about the,
See?
I was talking about those counts that were.
You some of those counts.
I said, don't send that to the county.
Okay.
I was telling him when I was upstairs, I said, I hope she didn't think I was talking about the Met.
You ain't going nowhere, you all right.
You sure ain't. 4 o'clock.
You said every day, right, okay.
Sometimes they do. They, if everybody is done, they might call and say, hey, y'all come get them, you know. I know, I get it, because they had them days when we, sometimes we'd be here till 6 o'clock. with
Exactly.
Defending that's supposed to be, coming from down there, they stuck.
That's real, we pay too.
And they supposed to get off at 4:30.
Oh.
And, we had a defender up here from down there, they can't go nowhere till we get through with it.
I will say, you gotta be careful. I know
When we go down there, Madam Clerk, they looking at us funny, like.
Do they? Like what's going on? Like a joke ball.
Right.
Right.
How she feel about that?
She looked just like, she kept me. She was throwing up, she you know, it's a mo. I think that might have been with the lady.
How long ago was it done downstairs?
Not long. So it's maybe 6, 7 months back.
How long does that thing away?
Probably right after that, like 4 months.
Oh, okay. Yeah, we got this. Is there gonna be a hold? No. Oh, it's not gonna be.
Yeah, there's no,
Yeah, you can send them back. Okay. All right. Afternoon, gentlemen. Good afternoon, Your Honor. One second to get official here. Okay. Mr. Villafan?
Yes, sir.
Calling case 2360539, people of the state of Michigan versus Quentin Rashad Villafan. Defendant is charged with count 1 assault with intent to grave bodily harm, thus to murder or by strangulation. Count 2 aggravated domestic violence. Defendant has a physical offender 30 testimony. Appearances for the record, please.
Good afternoon, Your Honor, Eric Decker, PA 5931 for the people.
And good afternoon, Your Honor, Hugh Marshall, P48269, on behalf of Mr. Quentin Villafan, who is standing to my right.
Tell me your name for the record, sir.
Quentin Villafan.
This date and time set for preliminary examination. Are we ready to proceed?
Your Honor, the people cannot proceed. The explaining witness, Ms. Hoskins is not checked into the courthouse.
Your Honor, I move for dismissal.
So ordered, the court will dismiss this matter without prejudice. I need to dismiss the one.
Okay, I'll sign it.
Approach.
Yes, sir. Does anybody know who Jacoby Easley is?
That sounds like a name we did this morning.
We did it Easley this morning.
I have.
Yeah, we sure did.
Yeah. You know,
Your Honor, one other issue, I presume with the dismissal of the temporary.
The dismissal order should take care of that.
Yes, thank you.
Oh. Yeah. Well, that's exactly.
Yeah.
Please call it attorney. Well, folks, that concludes the docket for today. Hope to see you tomorrow. Hope to see you Monday, same bed station, same bed time. Have a good weekend.
Thank you, Judge.